Go as the
You're ringing for help. It won't be any good. It's hard to believe anyone so charming has been involved in anything so unpatriotic. Did you? I'll take that on that. You rang for me? Miss Argyle, have you ever seen this case before? On numerous occasions. Where? By the lost and found, of course. Is it yours? Is it hers? I know, but sometimes when we admire a mislaid article, we just use it until the owner comes along. But we don't make a habit of it. Well, looks like apologies.
Okay, good morning, everyone. We are ready to call the case of TGCV 001-21 Gilmore versus Chimes Department Stores, Inc. Can anyone hear me all right? There's not audio problems or anything like that? Good. It looks like we have counsel for the plaintiff, Ms. Forster.
Yes, Your Honor. Good morning.
Good morning. And we have Ms. Appler, who's for the defense.
Yes, good morning, Your Honor.
Good morning. Counsel, do you have both of your second chairs here?
Yes, Your Honor. The defense has our second chair. So do I.
All right, perfect. And do we have our witnesses?
we're here.
Perfect. And it looks like we should have a jury of 4 jurors. Ms. Sheridan, who's here. Mr. Jones, who is here. Mr. Fenton, who is here. And Miss Go. Do we have Miss Go yet?
Yes, it's actually Avance. I got married a couple years ago, but I think they still use my maiden name.
My apologies. And we have Miss Avance, so I think we're good to go. Anyone else that council envisions needing during the trial?
Not from the plaintiff, Your Honor. I think we're all set.
Perfect. Then when you're ready, plaintiff's counsel, why don't you go ahead and make an appearance, and then defense counsel, you can make an appearance, and we'll take up any pretrial matters we need to take up.
Sounds good, Your Honor. Good morning. My name is Jenna Forster. I'm here today with my co-counsel, Cheyenne Smith. And together we represent the plaintiff, Mr. Jordan Gilmore.
Okay, for the defense.
Good morning, Your Honor. My name is Zoe Appler, and I'm joined today by my second chair, Ms. Valerie Letko. And today we represent the defendant, Chimes Department Store Incorporated.
That's great. Thank you both for being here and for announcing. Plaintiff's counsel, do you have any housekeeping matters or substantive pretrial matters to take up prior to opening?
Yes, Your Honor, we have some of each. We're happy to start with housekeeping.
Let's do that.
Yeah, sure. We have just one note about housekeeping, which is, given that we've never appeared in your Zoom courtroom before, when we are sharing or when we are offering exhibits into evidence, can we share those constructively on the screen outside the view of the jury, just so we can lay foundation, or would you prefer that we not share them until they're entered into evidence?
I don't have a problem with you sharing them constructively outside the presence of the jury. My only admonition would be if that's what you're going to do, make sure that we are making a record of that, so that there's no foibles about the jury seeing something not in evidence. Okay.
Understood. Will do. And then also, with documents that are already in evidence, would you like us to ask permission before we publish those to the jury, or can we just go ahead and publish them?
Once something is in evidence, you can consider it your right to show the jury.
Perfect. We've got a few substantive things, but I'm happy to turn it over to the defense for any preliminary matters first.
Sure, let's do that. Ms. Appler, do you have any housekeeping to take up?
Yes, Your Honor. First, we would like, Your Honor, and the court to take notice that today is a bifurcated trial, meaning that liability and damages will be tried separately. Today's case focuses on liability only.
Noted.
Next, we'd like to draw the court's attention to a pretrial agreement made between the parties that witnesses Kelly Danes and Perry Hayden are stipulated as unavailable today, and they may be called by deposition only.
Understood.
And Your Honor, to that end, we'd like to note that the defense intends to read portions of Perry Hayden's deposition onto the record today. And during that time, with the court's permission, of course, my co-counsel, Ms. Letko, will read the witness's answers as I read the questions.
That'll be fine.
And Your Honor, with that, we are happy to move on to substantive motions.
Okay, Ms. Forster, let's take up any substantive matters you have.
Sure. First, Your Honor, we were able to meet and confer with defense counsel before trial, and so we have a few stipulations for Your Honor's notice. One is that we've both agreed not to object to the either party's expert witness on the basis of 702. That's the witness that Ms. Appler mentioned will be called by deposition on both sides.
Okay, and let me say this. I do truly appreciate every time counsel meets and confers and tries to iron out any evidentiary matters. It makes the trial run much more smoothly. The one caveat I will have is that, as you probably know, the court has an independent gatekeeping function under 702. So if some witness starts spouting junk science, I might have a sua sponte duty to step in, but I don't envision that happening, and I do appreciate y'all confirming.
Understood, Your Honor. And if it's helpful, we did this keeping in mind that we're going to be calling these witnesses by deposition so that we could avoid boring Your Honor and the jury with some of the more technical, federal rule of evidence 702 background. We're happy to go into that when we're calling those witnesses by deposition if Your Honor would like, but we didn't intend to because of this stipulation.
And that's fine. And if the stipulation is to qualifications, then I don't think we'll have any issues.
Understood. We were also able to meet and confer and stipulate to the admissibility of many of the exhibits in this case. I'm happy to give Your Honor the numbers.
Yes, please.
It's 1 through 7, as well as 16 through 35. We'd actually like to offer those into evidence at this time.
Okay. Ms. Appler, did Ms. Forster correctly state your stipulation to
Yes.
pre-admit exhibits 1 through 7 and 16 through 35?
Yes, Your Honor, we have no objections to those being admitted today.
Okay, then exhibits 1 through 7 and 16 through 35 will be pre-admitted. Okay,
And with your honor's permission, plaintiff intends to use some of those exhibits during opening statements.
and that is fine. Once, as I said before, once something's in evidence, it's your right to show the jury anytime you want. So feel free to do that.
Much appreciated. Next, plaintiff would ask your honor to take judicial notice of certain portions of legal codes. I'm happy to share those on the screen at this time.
Sure.
There are 2 on this page and then 1 more on the next page. So let me know when your honor is ready.
I'm ready. Okay.
Great. And then lastly, plaintiff does have a motion. We move for a ruling regarding the admissibility of Exhibit 8, which is a photo of the knee of the plaintiff after the plaintiff's injuries were repaired at the hospital. These were injuries that were incurred when the plaintiff was working at his job, which was a workspace owned and controlled by the defendant. I'm happy to go into why we believe that document is admissible a little bit more.
I would guess it's something along the lines of you have to make a prima facie case of damages, and it also goes to liability. And the opposing counsel is going to argue that it's a bifurcated trial and you shouldn't be allowed to show pictures of the knee. Does that pretty much sum it up?
Sounds like this is all familiar territory to you, your honor.
Well, I think this is one of those evidentiary disputes that would be more easy to rule on in context. And so what I'd ask you both to do is to take it up during the testimony at the time you intend to offer it. Okay?
Will do.
Perfect.
And that's it from the plaintiff.
All right. Ms. Appler, do you have any substantive matters to take up for the defense?
Yes, Your Honor. Once again, in pretrial conference today, both parties did discuss a substantive motion that we had, and we both agreed to exclude any testimony regarding the installation of a light switch by the loading dock that was done by Chimes following the accident in 2019. Now, as the defense today, we are not disputing control or feasibility regarding this light switch, and therefore plaintiff's counsel has agreed that any testimony regarding this light switch would be improper under 407 as a subsequent remedial measure. So they've agreed that they don't intend to go down that line of questioning today, so long as we are not disputing control or feasibility, which we're not.
Okay, so noted. Anything else?
Your Honor, can I make one caveat to that, which is that defense counsel has represented that they do not intend to dispute ownership or control or feasibility. But if any of the witnesses today do dispute those, if a party representative of the defendant disputes those, then we would like to revisit that, given the exceptions in Rule 407.
Understood. Anything else on that matter?
Not from the defense, Your Honor.
Okay, Ms. Appler, do you have any other substantive matters to take up?
No, we don't, Your Honor. At this time, we're ready to proceed to opening statements. And we'd just like to make a note, as Ms. Forster did as well, that we intend to use one of the pre-admitted exhibits in our opening statement as well.
That's perfectly acceptable. All right, with that, Ms. Forster, you're free to proceed with your opening statement.
Thank you, Your Honor. I'll take just one moment to adjust my camera, if that's okay.
No problem.
Simple steps. The defendant could have taken simple steps to keep its employees safe, but it didn't. We are here today because of the defendant, a corporation called Chimes Department Stores. They operate a store right here in town, here in Waco. You may have been to that store. You may have parked in their parking lot, browsed up and down their aisles, checked out at the register. But where you probably haven't been, what you probably haven't seen, is the area behind that store. It's an area that looks like this. And this. And this. Peeling paint, crumbling concrete, a missing railing, a door that blocks the walkway, and there is a light, but no one knows how to turn it on. You will hear today that the defendant didn't just allow, didn't just encourage, it required its employees to use this area. It required them to use this area to take out trash to the dumpster and to smoke a cigarette on their break if they were going to. You will hear today the defendant could have taken simple steps to make that area safe, but they didn't. I want you to meet someone. Mr. Gilmore, could you turn on your camera for just a moment? Folks, this is Jordan Gilmore. He is the plaintiff in today's case. He's my client. Today you will hear that Mr. Gilmore was working at the defendant's store when one day he went out to take a smoke break, walked up those steps, and he fell. He shattered his knee. Thank you, Mr. Gilmore. Folks, where this story really starts is all the way back in 2005. Now, in 2005, Chimes is doing well. They're looking to expand. They're looking for a new location. And where they end up is the location that store still sits in today on Bosque Avenue here in town. Now, at the time in 2005 that they signed the lease and set up shop, that back area, those back steps, they look a little different. They look a little more like this. There is a railing around those steps, protecting anyone from falling off. But 2 weeks after the defendant moves in, they write an email to their landlord. They say that railing's gotta go. The landlord takes it out. Once that railing is gone, the defendant starts to use that area as a loading dock. They back up trucks to that landing. They move merchandise in and out of the store that way. But today you'll hear that when they start using that area as a loading dock, when they take that railing down, they don't stop using it for employees to take out the trash. They don't stop using it as the only place employees are allowed to smoke a cigarette on a break. And you'll hear today that area could be dangerous. You'll see that crumbling concrete. You'll hear that there was an outdoor light, but no one could figure out how the heck to turn it on. Folks, you will hear that Mr. Gilmore was not even the first person to get hurt on those steps. You'll hear that 10 years before Mr. Gilmore fell, another employee fell, slipped on that loose concrete, landed face first, sprained his wrist. You will see the defendant's own words in a report after that fall. In the defendant's own words, they needed to make sure there was adequate lighting in that area. But you'll see that they didn't. They didn't address the problem at all. So fast forward to January 23rd, 2019. Mr. Gilmore's been working as a cashier for the defendant for 10 years. That day he goes out onto the landing with a coworker to smoke a cigarette on his break. Now it's 7 p.m. in January. It's dark outside, it's windy. Mr. Gilmore, he's someone who has always tried his hardest to follow his employer's rules. That's why he goes out there in the first place. He knows that's the only place he's allowed to smoke. And that's why instead of standing on the landing, he walks down the stairs. Because he knows if his smoke from his cigarette blows back into the building, he might get in trouble. Now, he finishes his cigarette. He throws the butt in the dumpster. He goes to walk back up those stairs. And as he's walking up those stairs, the door is blocking his path. You'll hear today that door is blocking his path because there was no light outside. He and his coworker were doing the best they could. They had that door open to get the little bit of light they could, trickling from inside that building out onto that landing. It was windy. His coworker is standing in the doorway, trying to brace it open, trying to give Mr. Gilmore the light he can. Mr. Gilmore, he's got 12 inches of space between the edge of that door and the edge of that crumbling concrete. He does his best. He takes a step and he falls. He tries to jump for a clean landing, but it doesn't work. He lands on his right knee. He lands so hard, his knee is shattered. He has to get a full knee replacement. You will hear today that all of that could have been prevented if the defendant had taken just a couple simple steps. And that's why we're here today. That's why the plaintiff brought a claim of negligence against the defendant. Now, it's the plaintiff who's brought the claim, so it's the plaintiff who's got to prove it. We're going to do just that. We will show you 3 things. Number 1, that the defendant created an unreasonable risk of harm. Number 2, that the defendant knew or should have known about that risk. And number 3, that they didn't use ordinary care to protect employees against that risk. Because today the evidence will show that there were simple steps they could have taken, should have taken, and chose not to take. Mr. Gilmore's going to take the stand himself. He'll tell you about what happened to him. He'll tell you that in the moments after that fall, as his coworker helped him up off the concrete, helped him get inside, the very first thing he did was tell his manager what happened. You'll hear what his manager said. Yeah, we probably should have fixed those stairs a long time ago. You're going to hear those stairs weren't just dangerous, folks, they were also illegal. You will hear expert testimony about code violations on those stairs. You will hear that the law requires stairs like that to have a railing. The law requires stairs like that to have sufficient lighting. You'll hear the defendant had neither. You're going to hear a lot of testimony today. You're going to see a lot of exhibits. But I promise you, by the time you get to the end of this case, you'll see it's really not all that complicated. It is as simple as every one of the simple steps the defendant could have taken to keep its employees safe. At the end of this trial, I will come before you again. I will remind you that they didn't take those steps. I'll ask you to hold them liable. Thank you.
Okay, thank you, Ms. Forster. Ms. Appler, does the defense wish to make an opening statement at this time?
Yes, Your Honor, we do.
Okay, you may proceed whenever you're ready.
May it please the court, counsel, members of the jury. In this day and age, it feels more and more like things are becoming automatic. Automatic cars, phones, washing machines. Nothing's done manually anymore. We focus so much on speed, efficiency, instead of taking things a little slower, enjoying the journey. You're going to learn today that nobody understands this as well as businesses, small businesses like Chimes department stores. Once a one-stop shop for clothes, shoes, tools, businesses like these are slowly being replaced by quick online shopping, faceless transactions. But you'll hear today that even in this changing world, family-owned stores like Chimes, they strive to create warm, welcoming environments for their loyal customers and for their employees because, well, some things are just automatic. But members of the jury, you're also going to learn today that an accident doesn't automatically mean negligence. That's what today's case is really about. Good morning. My name is Zoe Appler, and I, along with my co-counsel, Miss Valerie Letko, we represent the defendant, Chimes Department Stores. Now, before we go any further today, I want to take a moment and tell you a little bit about Chimes, who they are, what they do. Now, today, I have the privilege of being joined at defense counsel table by Mr. Reese Geller. And you're going to meet Mr. Geller today. You'll learn that he's the third generation owner of Chimes. His grandparents opened Chimes right here in Waco. His parents took over. And finally, he took the wheel. You'll hear that he began working at his family's store right out of college in 1998, working his way up until 10 years ago. He was finally ready to take over the business. Today, you'll learn how much pride Mr. Geller takes in his business, how he works hard to make sure that Chimes serves its valued customers and projects a clean, well cared for, welcoming image. But above all, members of the jury, today you'll learn that Chimes Department Store is a safe store. Today, Mr. Geller will take the stand for you. He'll explain to you how safe his store was. And he's going to talk to you specifically about that loading dock that Ms. Forrester just mentioned, a crucial part of Chimes' business and the area where the plaintiff says that he fell. Mr. Geller will take you back to 2005, and he'll tell you at that time Chimes was doing really well. So well that they decided they needed a bigger space. So he packed up his store and he signed a lease for a spot at a strip mall, Bosque Avenue. Now, right away, it was clear to Mr. Geller that in order to adequately conduct his business, the store needed a loading dock, one that could handle the volume of the deliveries it received. And you're going to see that loading dock today. You'll see that in the back of this building, there was a small cement platform, less than 3 feet high, that jutted out from a set of double doors. And it was originally surrounded by a small railing. Mr. Geller decided to convert this platform into the loading dock. He had the railing removed. He had this driveway installed so that trucks could back right up to it. And he'll tell you, this setup worked great. Deliveries are still made every single day to that loading dock, allowing Chimes to get all of its products on the shelves to its customers. Now, you'll also learn that this area became the designated trash collection area with a dumpster that was placed beside it. And it also became the designated smoking area. Now, in 2021, smoking cigarettes isn't quite as common as it used to be. Today, it's even considered taboo by some. Mr. Geller and Chimes didn't mind if their employees smoked. They didn't even mind if they smoked while they were at work. All they asked was that it be done out back so that the smoke didn't bother the customers. Now, you'll hear today that this new smoking policy went into effect in 2015 and that until January 23rd of 2019, it had never been a problem. But on that evening, around 7 p.m., the plaintiff went outside as he normally did for a smoke. You're going to hear today that the plaintiff has probably been on that loading dock thousands of times, maybe even more. But on that night, he fell. And today, he's suing Chimes department store for that fall. But the evidence will show you today that Chimes was not negligent. In fact, in addition to Mr. Geller's testimony, you're going to hear testimony from an occupational safety and health administration officer. That's an officer from a federal agency called OSHA, and that's Perry Hayden. Now, unfortunately, Ms. Hayden is unable to be at trial today, and she's been designated by the court as unavailable, but don't worry. All that means is that instead of Ms. Hayden coming on screen here today, testifying live, you're going to hear portions of her testimony from a previous deposition read to you by myself and by my co-counsel, Ms. Letko. And Ms. Hayden's testimony will make it clear to you today that Chimes department store acted in accordance with all federal guidelines, particularly those made by OSHA that applied to loading docks. The evidence will show that this store was safe, that loading dock was safe. I want to make something very clear here today. The plaintiff has brought this negligence claim, not us. So that means that the plaintiff has the burden. They have to prove to you that Chimes was negligent by a preponderance of the evidence. It's going to be something they fail to do. Because in order to prove negligence, they have to prove to you that Chimes breached their duty of ordinary care, and that this breach caused the plaintiff's injuries. Now, that might sound a little confusing right now, but I promise you, at the end of today's trial, I'm going to come right back here before you, and I'm going to walk you through piece by piece, element by element, how the plaintiff has failed to meet that burden. Now, in the meantime, I ask that you pay close attention to the facts, to the evidence, because they're going to show you that Chimes department store didn't breach any duty of care. It's easy to jump to conclusions, to want to point a finger if someone gets hurt, to try and place blame, pinpoint what went wrong. We're only human. Members of the jury, that's exactly the point. We're humans. Sometimes we walk and stub our toe. We bump our elbow on the edge of a counter as we walk by. We lose our footing and roll an ankle. Accidents. But accidents don't automatically mean negligence. And we are fortunate enough that in our society, the law is one area where few things are ever automatic. The law requires slow, careful deliberation. And at the close of today's trial, I'm going to come before you again and ask you, after your careful deliberation, to return the only verdict in this case supported by the evidence and demanded by law. I'm going to ask you to find Chimes department store not liable. Thank you.
Okay, thank you, Ms. Appler. Ms. Forster, you may proceed to call your first witness at this time.
Plaintiff calls Jordan Gilmore.
All right, Mr. Gilmore, you're advised that you have been previously sworn and you have the obligation to tell the truth today, okay?
Yes, sir.
Ms. Forster, you may proceed whenever you are ready.
Thank you, Your Honor. Good morning, Mr. Gilmore.
Good morning.
Can you tell us a little bit about yourself?
Sure. Again, my name is Jordan Gilmore. I'm from Waco, Texas. Lived here most of my life. I'm pretty involved in my church, 7th and James Baptist Church, in the Sunday school class there. And there's a book club on Wednesday nights too that I really enjoy. And some friends from the church I'll have over from time to time, about once or twice a month, to play cards over at my house.
Mr. Gilmore, do you work?
Not currently, no.
Where was your last job?
My last job was with Chimes department store.
Can you tell the jury just what is Chimes?
Chimes is just a department store, kind of like a Macy's or a Dillard's. That kind of store sells just about everything, but maybe a kind of like lower end stuff, just for like the local Waco market, not something you necessarily find in a Dallas or Houston store.
So what did you do when you worked at Chimes?
I was a cashier, check out at the front.
How long did you do that?
I worked there for about 10 years.
When did you stop working for the defendant?
I stopped working after the accident, after I fell.
You mentioned the accident. When was that?
That was on January 23rd, 2019.
Where roughly on the premises did that accident happen?
Behind the store, at the back landing area, back stairs.
I want to talk about that area. And we're publishing Exhibit 2, which is already in evidence. What is that platform in the center of this picture?
That platform is the back landing area.
And those double doors we can see there, where do they go?
Those go into the back of the store.
Mr. Gilmore, I see in the upper left-hand corner a red circle. What's inside that circle?
That in the circle was the only light that was there behind the store.
I'm going to come back to that light later, but first I want to show you Exhibit 17, which is already in evidence as well. Are these the same stairs we were just looking at?
Yes, those are.
When did you use these stairs?
Pretty regularly. Most days whenever I would take a smoke break, or if I went out back to throw some trash in the dumpster.
So about how often did you normally go out to this back area?
Probably about 20 times a week, I would say.
Did you ever have to go out here? Oh, and thank you, Ms. Smith. Did you ever have to go out there when it was dark?
Yeah, sometimes I did.
Let's talk about the lighting back there. A few moments ago, you mentioned that light circled in red. If you had to go outside in the dark, could you turn on that light?
No, we didn't have a switch for that light.
You didn't have a switch for that light. Where was the switch?
We were told the switch was in the store next to us.
If you didn't have a switch for the only outdoor light, did you ever tell a manager about that problem?
We brought it up to management, but they just said that the switch was next door, and that, because it was next door, they couldn't do anything about it.
To your knowledge, in your 10 years of employment, did you ever once see that outdoor light turned on?
Not as far as I can remember, no.
If that outdoor light was never turned on, did the defendant ever put a lamp outside so that you could see?
Not while I worked there, no.
Did the defendant ever put a flashlight by the door for you to use?
Not that I'm aware of.
Did the defendant ever paint a white stripe on those steps so you could see them better in the dark?
Not that I'm aware of, no.
Let's talk about those steps for just a moment. In your 10 years of employment, was there ever a railing around those steps?
Not that I can recall, no.
Can you describe the condition of those steps for the jury?
I mean, as that picture we saw, they were just kind of old and worn out, uneven, chipped paint, just old, worn out concrete steps.
Well, now that we know what the landing looked like, I want to move on and talk about the day you got hurt on that landing. You told us it was January 23rd. Do you remember about what time it was?
It was after the sun went down. I think it was around 7 o'clock that night.
You said it was after the sun went down. So is it fair to say it was dark outside?
It was, pitch dark. It was really dark outside.
Was that outdoor light on?
No, it was not.
Were you alone?
No, one of my coworkers, Riley, was with me.
Your coworker, Riley, where was your coworker standing when you were outside?
She was standing up on the landing, back landing, holding the door open.
Did you stay on the landing too?
No, I went down the steps.
Why did you go down the steps?
Well, I didn't want to be very close to the doors because I was out there taking a smoke break, and I didn't want my cigarette smoke going inside the back of the store.
Why didn't you want your cigarette smoke going into the store?
Well, I mean, there's customers inside, and I don't think management would want to have cigarette smoke lingering inside the store.
At some point, did you finish your cigarette?
Yeah, I did.
What did you do then?
I mean, it was cold outside, so I was headed straight back up to go inside.
What happened?
Well, I started walking up the stairs because I had gone down there, and then as I was trying to step around the door, that's when my right foot slipped, and then that's when I started to fall.
I want to take a moment to make sure that the jury really understands what happened. We're going to show you Exhibit 3. Is this a photo taken from the top of that landing?
Yeah, looks like it, yes.
Now, you told us that your coworker Riley was standing on that landing. Can you just describe where that would be using this photo?
I mean, she was standing on this side of the door where whoever was taking the picture was standing. She was holding the door open, kind of like how it is right now, just sticking out from the building like that.
I'm going to mark an RH on the right side of that photo. Does that accurately reflect where Riley Huntsberger, your coworker, was standing?
Yes, it does.
Where were you when you were smoking your cigarette?
Just kind of to the left in this picture, just down the stairs, away from the back door.
I'm going to mark an X near the bottom of the stairs. Does that accurately reflect where you were standing?
It does.
Now, you said a moment ago that this is the position that door was in when you tried to walk up those steps. Why?
Well, Riley was holding it open like that, and our only source of light out there was coming from inside the store. So she was holding the door open so we wouldn't just be standing in the dark out there.
Was it windy that night?
It was windy that night.
Was Riley having to hold the door open against the wind?
Yeah, I think she was also holding it like that so it wouldn't, slam up against the building or slam shut and hit somebody.
You said the only light you had was the light that was coming out of those doors. Was that enough light to see where you were going?
Barely.
So what happened as you tried to walk up those steps?
As I was walking up the steps, my right foot slipped as I was trying to step around the door because it was in the position that the door's in right now. I was trying to step around it. My right foot slipped, and then I realized immediately that I was falling.
What did you do?
Well, I knew I was falling and I didn't want to get hurt. So I kind of hopped off the ledge where I was the best I could and tried to land on both feet to catch myself. But the ground there was kind of uneven where I was landing, and most of my weight landed on my right leg, and I immediately fell to the ground on my butt.
When you fell, what did your coworker do?
She immediately, told me to stay still, I think, and asked me if I was okay and to not try to get up or to do anything to further injure myself if I was injured at that point.
Did she help you inside the building?
She did. As I started to walk up the steps, I realized that I was hurt and that my leg was in pain, but she helped me walk inside.
Did you ever tell anyone in the defendant's management what happened to you?
Yeah, inside I went and talked to the store manager and told her what happened.
When you told the store manager that you had fallen on those steps, what was her response?
She said something like, yeah, we probably should have fixed those stairs a long time ago. She said that she had talked to the owner about it a few times, but it seemed like I always had bigger problems to take care of rather than putting a railing back there on those back steps.
Mr. Gilmore, I want to talk about your injuries. I'm going to share with you, constructively outside the view of the jury, Exhibit 8. What is this?
This was my right knee after the procedure.
What was the procedure?
Pardon, what did you say?
What was the procedure that you had to go through after falling?
I ended up having to have a total knee replacement on my right knee.
Is this photo a fair and accurate description of how your knee looked after that surgery?
Yes, it is.
Plaintiff offers Exhibit 8.
Okay, any objection to Exhibit 8?
Yes, Your Honor. We object under 403 and 401. May I be heard outside the presence of the jury?
You may.
Your Honor, this is substantially more prejudicial than it is probative. Now, Ms. Forrester just got onto the record that Mr. Gilmore was injured in the process of this accident and that he had to have a knee replacement. Now, in order to show this rather gruesome photo to the jury is going to substantially prejudice them today. Now, in addition, this is irrelevant under 401 as today's proceedings are regarding liability and this goes to damages.
Okay, Ms. Forrester, your response?
Yes, Your Honor. First to 401, this isn't irrelevant because as Your Honor noted earlier, the plaintiff has a duty to prove that there was an injury in today's case. This photo does just that, and so it's probative on that point. Second to 403, evidence can only be excluded under 403 if it is substantially more prejudicial than it is probative. The fact that this is a gruesome photo does not on its own mean that this is inadmissible. And there is probative value here, both to show that there was an injury, but also, Your Honor, because one of the elements that we have to prove today is an unreasonable risk of harm. Now, as I understand defense counsel's argument, it's that essentially those steps were just not that bad. The fact that this is the kind of injury that could result from those steps, that goes to show the condition those steps were in was unreasonable. That's why it's relevant and why the probative value outweighs the prejudice.
Okay, Ms. Appler, you get to have final word.
Yes, Your Honor. At this point, Ms. Forrester has established that this injury has occurred. Now, the confines of what their prima facie case is today have been established that this injury occurred. And she can lay that foundation that Mr. Gilmore had to have surgery, that he had to have stitches, but to show this exact photo to the members of the jury is still substantially more prejudicial.
Okay, thank you both for that argument. It was helpful to the court. The objections overruled and Exhibit 8 will be admitted into evidence. Ms. Forrester, I assume that the predicate you laid has been in front of the jury, even though the exhibit was not. So you may now show the exhibit to the jury.
Understood. Thank you, Your Honor. Mr. Gilmore, do you remember how many stitches you had to get?
I think it was 28.
How is your knee today?
I mean, it still hurts. It feels weak. I have a long-lasting scar that I don't think is ever going to go away. I still feel some numbness in my leg and around where the scar is.
Objection, relevance. May I be heard outside the presence of the jury, Your Honor?
You may.
Your Honor, at this point, the answer given by the witness does go exactly to damages, the extent of his injury, whether or not it still hurts. All of that has to do with his injuries following what the actual injury was. Therefore, it is irrelevant in this bifurcated trial.
Ms. Forrester, do you want to respond?
I do, Your Honor. I'll start by saying that is the last question and answer I intend to ask on this point. I'm not going to proceed further down this path, but it is relevant, again, to go to that first element of negligence, that the risk of harm created by those steps was unreasonable because it could cause such severe and such permanent injury to someone like Mr. Gilmore.
Okay. I tend to agree that the last response given by the witness was a little bit more than was necessary at this time in this stage of the bifurcated trial. However, the jury heard it. And so to the extent that the objection was untimely, I'm going to overrule it. But please, Ms. Forrester, do move on and don't ask any more questions about damages. Okay?
Your
I
Honor,
will do just that.
Your Honor, may I move to strike the testimony that came onto the record?
If you want me to instruct the jury to disregard what they just heard, I can give them that instruction. Is that what you want?
Yes, Your Honor.
Okay. The jury is to disregard the last response by the witness. Okay. You may proceed, Ms. Forrester.
Will do. Mr. Gilmore, I want to back up. Can you tell the jury why you were taking your smoke break on that loading dock in the first place?
We were instructed to do so by management from the store.
How did they give you that instruction?
They sent out a memo at some point instructing us to smoke out back and to not ever take a smoke break in front of the store.
I want to show you that memo. Exhibit 1, it's already in evidence. Mr. Gilmore, we're going to blow up part of this memo. Ms. Smith is going to highlight starting from if you're going to smoke. Mr. Gilmore, can you read this highlighted portion for the jury?
Sure. It says, if you're going to smoke, you need to smoke out behind the store where our dumpster is. That is the only place you should take smoke breaks on the premises.
In this memo where the defendant says you have to take your smoke breaks behind the store, does the defendant warn employees that the light back there doesn't work?
No, don't think so.
Does the defendant offer employees a flashlight?
No,
Does the defendant warn employees to make sure the inside lights were on and the doors were open?
no,
Does the defendant warn employees at all?
no, yeah.
Thank you. Pass the witness.
All right, Ms. Appler, do you have a cross-examination for this witness?
I do, Your Honor. May I proceed?
You may.
Good afternoon, Mr. Gilmore. Can you hear and see me okay?
I can, yes.
I'm just going to ask you a few questions here today on behalf of the defense. Now, you say that you were injured while you were at work, correct?
Correct.
You were working 12 to 8 that day.
I was,
Fair to say it's a pretty normal shift for you, right?
yes.
But you weren't working at the time that you were injured, right?
I was taking a smoke break.
Right. You weren't performing one of your job duties as a cashier.
No, I wasn't.
Fair to say that you take smoke breaks pretty often at work, right?
I do.
At least once a day.
Yep.
And like you said, that involves you going out back to the loading dock, doesn't it?
Yes, it does.
Now, you'd estimate that you were out back on that dock around 20 times per week. Do I have that right?
Yes, that's correct.
You'd also go out back to take out the garbage sometimes
Yes.
when there were deliveries.
Yes.
And you'd do this during the day.
Yeah.
You'd also do it at night.
Yeah.
Prior to you losing your job with Chimes, you had worked there for 10 years, correct?
Correct.
And that memo that Ms. Forrester just showed you, that was from 2015, right?
I think so, yeah.
So for 4 of those years, that was when you were required to go out back to smoke.
Yeah.
So bear with me here, Mr. Gilmore. If I've got my math right, 4 years of going out back to that loading dock around 20 times per week, that would be around 4,000 occasions total you've gone out back?
I'm not good at math. I trust your number if that's what a calculator would say.
Say it's 4,000 or so times you spent on that loading dock. Prior to January 23rd of 2019, you had never injured yourself out there, had you?
No, I had not.
Okay. I want to talk to you about January 23rd then. You said you went outside to smoke at 7 p.m. that night, right?
Yep,
And when you got out there, it was dark,
it was.
but you could still see, right?
Somewhat.
Well, you said there was light coming in from the door to the outside, correct?
There was a little bit of light coming in.
It was enough light that you could still see the steps, couldn't you?
Kind of.
You could see the landing.
Yeah, I could kind of see it.
You could see your coworker, Riley, standing beside you.
Yes,
And you had no difficulty getting down those steps, correct?
correct.
You'd gone out to smoke at night on that dock before.
Yes.
And in the past, the amount of light back there, well, it had never been an issue for you, had it?
I mean, that was the same amount of light as normal.
But it had never been an issue for you in the past.
Depends. No, not that caused me an injury, no.
Well, if it had been an issue, Mr. Gilmore, wouldn't you have brought a flashlight with you?
I mean, I could have.
In fact, you owned an iPhone with a flashlight on it back in 2019, right?
I did.
And that night of the 23rd, you didn't think you needed it to go out for your smoke.
No, I wasn't going to be out there for very long. I left my phone inside.
All right, I want to talk to you about that doorway. Now, you said that your coworker Riley was standing in the doorway, right?
Yes.
Now I'm showing you what's already in evidence as Exhibit 6. Can you see that okay, Mr. Gilmore?
I can.
Now, there are actually 2 doors on this doorway, right?
Yes.
We can see here there's one on the left
Yeah.
and one on the right, right?
Yep.
And as we can see by this photo, that door on the left can open completely, can't it?
It can.
To the point that it's flat against the wall.
Yeah.
Now, neither door in this picture is blocking those steps, correct?
Correct.
Now, you and Riley came out of that left door, right?
Correct.
And Riley only opened that left door part of the way.
Correct.
So like you said, it was blocking some of the stairs, right?
Mm-hmm. Yes.
And you'd agree, Mr. Gilmore, that if this door was open all the way, it wouldn't be blocking the stairs.
Correct.
Retrieving the exhibit. Now you say that while Riley was holding the door, she was blocking some of the light, right?
Yes.
But you never asked her to move.
No, I didn't.
You never asked her to open that door wider.
No, I didn't.
You didn't ask her to open up that other door on the other side for more light.
No, I didn't.
Well, because even with her blocking some of that light, you could still see well enough to navigate those stairs, couldn't you?
I can see a little bit.
All right, well, let's talk about those stairs now then, Mr. Gilmore. I'm going to publish what's already in evidence as Exhibit 18. Can you see that okay?
I can.
Now, this is a photo of those stairs by the loading dock, right?
It is. Yeah.
So the concrete on these stairs specifically, that concrete has never caused you any injuries before, right?
No.
You've never tripped on any loose concrete from those stairs.
I may have tripped walking up and down the stairs as people do sometimes. So
But you never tripped on any loose concrete, right?
I don't think so.
And on January 23rd, you'd say you walked up the middle of those stairs, correct?
Right.
Not near the edge.
No.
Now, looking at the middle of these stairs, there are no cracks, right?
Not that I can see. No.
No chunks of concrete missing?
No, not in the middle. No.
Retrieving the exhibit. Now, finally, I want to talk to you about that railing. Now, you mentioned that there was no railing attached to that loading dock, right?
Correct.
And in your 10 years working at Chimes, there was never any type of railing on that dock.
Yeah, not to my recollection. No.
And not on the stairs, right?
Correct.
Mr. Gilmore, you never complained to anyone at Chimes about there not being a railing, right?
We brought up to management that there was no railing back there.
Is it your testimony you brought up to management that there wasn't a railing in the back?
Yes,
You remember being deposed, correct?
I do.
A moment of the court's indulgence, Your Honor. We're just going to pull up Mr. Gilmore's deposition.
Sure, take your time.
Now, Mr. Gilmore, you remember being deposed on June 1st of 2020?
Yes.
You were deposed by Guillermo Paquito.
Yes.
And this deposition, it was taken between 1 p.m. and 3 p.m., correct?
Yes.
You'd recognize that deposition if I showed it to you today?
Yes.
Your Honor, permission to publish Mr. Gilmore's deposition outside the presence of the jury?
Sure.
Can you see that okay?
Yes, I can.
I'm just going to zoom out for you here. So this is your deposition, correct?
Yeah,
Scrolling through here looks to be fair and accurate to you.
it does.
And getting to the bottom here on this last page, that's your signature on the last page, correct?
It is.
During the course of this deposition, you were told to be truthful.
I was.
You were told to be complete.
Yes.
And you were told to add anything at the end of the deposition that hadn't been covered by counsel.
Yes.
And Mr. Gilmore, you'd agree with me, nowhere in this deposition do you say that you told management about concerns about not having a railing.
I'd have to read through it again to confirm that.
Take your time. If you have it in front of you, Mr. Gilmore, go right ahead. But if you can point me to a line, feel free.
Okay. You want me to read through it? I do have it in front of me.
If I can actually direct your attention to page 9, Mr. Gilmore, or page 8, excuse me, line 9. It says there that the only time that you ever complained to management was regarding the light, correct?
Which line did you say?
Line 9.
Line 9.
Beginning at line 9, it's specifically on line 10.
Yes, it does talk about the light.
But nowhere in here does it say you complained about a lack of a railing.
Not in lines 9 through 13. No.
Nowhere in the deposition, correct?
Again, I'd have to read the entire thing to confirm that.
Let's take a look at line 19 then. You were asked, had you ever complained to anyone at Chimes about the lack of a railing on that loading dock? Line 21, you answered no. Did I read that correctly?
You did.
Retrieving the exhibit. Excuse me, the deposition. So you'd agree, in your 10 years working at Chimes, you never complained to anybody about that railing not being there?
I guess I didn't.
Thank you, Your Honor. I have no further questions.
Okay, Ms. Forster, do you have a redirect for this witness?
I do, Your Honor.
You may proceed.
Mr. Gilmore, did you complain about the lighting?
I did complain about the lighting.
After you complained about the lighting, did anything change?
Not that I'm aware of, no.
Thank you. That's all.
Ms. Appler, do you have any cross-examination that's necessary?
Not based on that, Your Honor.
Okay, then may the witness step down.
Yes, Your Honor.
Okay, Mr. Gilmore, you may step down. Please do not leave the courtroom yet, though. Ms. Forster, you may now call your next witness.
Plaintiff calls by deposition Kelly Danes, and I'd ask for my co-counsel, Ms. Smith, to help me show this to the jury.
Certainly. And Ms. Forster, have you given these page and line designations to opposing counsel?
I haven't given them specifically, but I'm happy to say the page and line numbers before we start reading the portions that we're going to read.
Please do that. And also, if you could just give a pause so that opposing counsel could catch up to you before you start reading.
Will do.
Thank you.
We're gonna start on page 2, lines 6 through 7. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Kelly Danes.
Page 2, lines 12 through 14. Tell us about your education.
I have a Bachelor's of Science in Mechanical Engineering from the University of Wisconsin-Madison.
Page 2, line 24 through page 3, line 7. I noticed that your CV lists you as a PE. What is that?
It stands for Professional Engineer.
What do you have to do to become a professional engineer?
Well, you have to graduate from an accredited engineering program, which I did. Then you have to pass the Fundamentals of Engineering exam, which I did. Then you work as an engineer for 4 years before you take the Professional Engineering exam. So I took that as well, and I passed.
Moving to page 8, lines 16 through 20. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question, and the facilities in question must be in compliance with those codes and regulations.
Moving to page 15, lines 7 through 15. Any final thoughts?
Honestly, I just don't know what the defendant was doing here. All of this could have easily been fixed by putting up a guardrail around those stairs and landing and patching the concrete on those steps. It would have been easy. And if the defendant had taken these simple steps, putting a guardrail along those stairs, putting a guardrail around that landing, making sure it was well lit, patching the concrete, then the plaintiff's fall would not have happened.
Thank you. Nothing further. Pass the witness, so to speak.
Okay, Ms. Appler, do you have any portions of this witness's deposition to read in cross-examination?
Yes, Your Honor.
You may proceed whenever you're ready.
If we could direct the court's attention to page 14 of the deposition, which is page 92 of the record for Your Honor's reference, lines 12 through 21. You would agree, though, that this area was used by Chimes as a loading dock at times.
Yes, at times.
And a guardrail around that loading dock would certainly inhibit Chimes' ability to use it as a loading dock.
Yes, it would make it difficult.
Can you point to any specific regulations or codes related to how or if employers or others must place guardrails around loading docks?
No, I'm not aware of anything like that.
Thank you, Your Honor. We have nothing further.
Okay. Ms. Forster, do you have any additional passages of this witness's deposition to read in?
No, Your Honor, we do not. And in fact, plaintiff rests our case at this time.
Okay. In that case, defense, is there any matter that you would like to take up outside the presence of the jury?
Yes, Your Honor, we would like to make a mid-trial motion. However, we're happy to do it after the break if Your Honor would like to take 5 before.
Well, shedding the fiction for a second, if we were to grant the motion, then we wouldn't have to have a break. But why don't we take up the motion now, and then we can take a break?
Absolutely, Your Honor. Now, pursuant to Civil Rule of Procedure 50, the defense moves for a judgment as a matter of law. Now, viewing the evidence in the light most favorable to the non-moving party, no reasonable trier of fact would be able to find for the plaintiff at this point. Now, in this case, the plaintiff has the burden of proving by a preponderance of the evidence that Chimes department store was negligent. And in order to do so, they had to show that a breach of duty occurred, and they haven't done that. We've heard no testimony that Chimes lighting was inadequate under the federal standards that are set by both OSHA and the IBC. Now, Mr. Gilmore testified he could see and that he had navigated those stairs thousands of times without any light other than from that door. We've also heard no testimony that loading docks are required to have railings under federal law. And that's not a breach. Because they didn't install a railing, that doesn't mean that they breached a duty. It's a loading dock. And furthermore, Your Honor, we've heard that Chimes, or I should say we haven't heard that Chimes has violated any federal standards. They haven't shown that the breach of duty occurred. Therefore, viewing the evidence in the light most favorable to the non-moving party, no reasonable trier of fact could find for the plaintiff at this point.
Okay, Ms. Forster, your response?
Yes, Your Honor. First of all, the legal standard in this case is not whether or not the defendant violated a federal standard or building code. The legal standard in this case is negligence. It's a duty of ordinary care. We have certainly demonstrated that the defendant violated that duty. We've demonstrated it such that any reasonable juror could find that, that the defendant violated that duty by providing those stairs only in the condition that they were in. Now, it's true that federal standards are not the standard at issue today. The standard is negligence, but we did hear expert testimony that those stairs violated federal standards as well, both the lighting and the lack of railing itself. That is certainly plenty for a reasonable juror to find that, that the plaintiff's proven its case at this point.
Okay, Ms. Appler, you get final word.
Your Honor, I stand by my previous argument.
Great. The motion is denied without prejudice. And so we will proceed to the defense case in chief. I assume, Ms. Appler, you want to put on a case in chief?
Yes, Your Honor.
Okay, before we do that, we're moving at a pretty good pace here. So why don't we take a 10-minute break? And I don't know what time zones y'all are in, but we are in the central time zone, and here it is 11:05. So let's plan on returning at 11:15 central time for the defense to put on its case in chief. Does that sound good?
Sounds good, Your Honor.
Yes, Your Honor.
Okay, I will see y'all then. All right. We have everybody back. Sounds good. Ms. Appler, would you like to proceed with your case in chief at this time?
Yes, Your Honor, we would.
Before we do that, can we have a quick time check with the timekeepers so that we just know how we're tracking? I have, and I'm welcome to other opinions, but I have that the plaintiff has used 29 minutes out of 55 total, and that the defendant has used 17 minutes out of 55 total. Does that roughly track where other people are?
That is what we have as well.
Okay, Ms. Appler, you may proceed.
Thank you, Your Honor. At this time, the defense calls Mr. Reese Geller to the stand.
All right, Mr. Geller, you are advised that you have been previously placed under oath and you have the obligation to tell the truth. Okay,
Yes, sir.
you may proceed.
Good afternoon, Mr. Geller. Can you see and hear me okay?
I can. Can you see and hear me?
Yes, all good. Thank you very much. Would you please introduce yourself to the members of the jury?
Hello, I'm Reese Geller.
Where do you live, Mr. Geller?
I live here in Waco.
Do you have any family here?
Yeah, I've got my lovely wife, Peyton, and my 3 adorable kids, Jerry, Jim, and Liz.
What do you do for a living, Mr. Geller?
Well, I own the Chimes department store here in Waco.
Can you tell us a little bit about it?
Yeah, so it's a family-run business. My grandparents started it years ago, and then once my parents were old enough to take over, they did. And about 10 years ago, my parents trusted me to take over the reins on the Chimes department store. And so now I run it, and I hope one day my kids can take it over from me.
Where is your store located?
On Bosque Avenue.
Was it always located there?
No, we moved over there in about 2005. We had been doing really well, and so we wanted to get a little bit of a bigger space. So we moved there in 2005.
Now, Mr. Geller, I want to shift gears here and talk about why we're in court. Are you familiar with an individual named Jordan Gilmore?
Yes.
How do you know him?
He used to work for me.
How long did he work for you?
About 10 years.
Are you aware of the allegations that Mr. Gilmore has made against your store and its safety conditions?
Yes, I am. It's unfortunately the reason why we're here today.
All right, Mr. Geller, I want to take a step back and have you walk us through the layout of your store. Are you aware of where this incident was said to have taken place?
Yes, it was the loading dock area.
Just for reference for the members of the jury, what is a loading dock?
So a loading dock is where we'll get our shipments of new goods, and we'll unload them from the truck. So the truck will back right up there. And then we take our products off the truck and bring them into the store.
And is this loading dock in the front of your store or the back?
It's in the back.
All right, first I'm publishing what's in evidence as Exhibit 16. Can you see that okay there?
Yes, I can.
Can you tell the members of the jury what we're looking at?
Yes, so this is the driveway that I put in, and then it goes right up to the loading dock there with the stairs, and you can kind of see those doors, but they're right there.
All right, moving on and looking at Exhibits 31 and 32, I'm publishing these side by side for the members of the jury. Can you tell us what we're looking at here?
Yeah, so this is that loading dock here, and kind of shows the process of what we do. We get those goods there, those boxes, and trying to take them in. And so it's a loading dock. We can have the truck back up, which we normally would, and just take those right off instead of having to lift them up.
Now, in this picture, this concrete platform that we see there, how high is that?
Not very high. It's about 3 feet.
Mr. Geller, I want to be clear here. There's no railing on the loading dock in these photos.
No, ma'am.
Why is that?
Oh, well, as you can see, if there was a guardrail, we couldn't really move those boxes in. And so with any loading dock, you're not going to have a railing there because it would defeat the purpose of having a loading dock.
Let me ask Mr. Geller, was there ever a railing on this loading dock?
Yeah, way back when we first moved into Chimes, there was a guardrail, and then we had that removed so we can make it into a loading dock.
Now, how often does your store receive deliveries like the ones in these pictures?
Every day.
All right, retrieving these exhibits. So other than deliveries like the ones we just saw, was this loading dock used for anything else?
Yeah, so we had our dumpster out there, so we'd take out the trash out of the loading dock. And then if our employees wanted to take a smoke break, that was one of the areas where they could go to take a smoke break.
And as the owner of the store, was that your decision to have employees smoke back there?
It was. We're a family-run store, and we want to make sure that everyone feels comfortable in our store. And so we didn't want people that were smoking in the store or right outside the front door, so no one has to walk through that. And we didn't want big piles of trash right outside our store, and so we put all that in the back.
Mr. Geller, could your employees have smoked anywhere else other than the loading dock near your store?
Sure, they could have gone to their car. They could have, walked down the block. They could have waited till they got home to smoke.
Now, do you know if Mr. Gilmore was taking out the trash on the night that he fell?
I don't believe he was taking out the trash, no.
Do you know what he was doing?
I believe he was taking a smoke break.
Now, this smoking rule that you have, when did that go into effect?
Several years back. I want to say maybe about 4 years ago.
And in that period of time since that smoking period has begun, did any of your employees ever complain about not having enough light back there?
Not that I can recall.
During their smoking breaks specifically?
I don't recall there ever being a problem with the lighting.
Now, Mr. Geller, I want to talk about the safety measures that you've implemented at your store. As an employer, are you aware of any safety standards that you have to follow?
Sure. We always have to follow the OSHA standards to make sure that we have a safe workplace.
And OSHA, that stands for Occupational Safety and Health Administration, right?
Correct.
And you follow these standards?
Yes, ma'am.
How are they enforced at your store?
So with OSHA, we'll randomly get inspected at times from someone from that agency. And they'll come by and they'll do a inspection of the store, look at the different areas, and let us know if we have any violations that we need to fix.
So prior to January 23rd of 2019, had your store ever been inspected by OSHA?
Yes, ma'am.
When was that? 2018,
I believe.
And as a result of that inspection, did you ever receive any notice that you were violating a safety standard?
Nope, we were given the 2 thumbs up.
Did you receive any citations for a violation of a safety standard?
No, ma'am.
All right, now I want to talk to you about the steps that are behind that store by the loading dock. You're familiar with this area?
Yes.
And based on your knowledge and observations, did anything appear to be wrong with the concrete on those steps to you?
Not really. I mean, there was a little bit of chipping on the sides as you get with concrete, but overall, I mean, there were sturdy steps.
As the owner, did you ever have any safety concerns about that loading dock?
No, not as long as you take proper precautions yourself when you're going out. It should be pretty safe.
I want to talk about the lighting in that area. Was that area adequately lit at night to you?
Yeah, I believe so.
Why do you say that?
We see when you open those doors to go out into the loading dock, we have some big fluorescent lights right there. And so when you open up those doors, it shines pretty brightly outside.
I'm publishing Exhibit 31. Can you see that okay?
I can.
You mentioned that there were lights. Are those the lights in this picture?
Yeah, you can see kind of towards the top of the screen over those black boxes is one of the sets of lights.
This photo, was it taken during the day or at night?
As you can see, it was taken during the day. So even during the day, those lights are shining pretty brightly.
All right, retrieving the exhibit. Were there any other lights on the exterior of that building?
I believe there was, yeah, there was an exterior light, but I don't think the light switch was in our store.
And if that exterior light wasn't on at night, could you still see around the loading dock?
Of course, whenever you open one of those doors, that light's going to shine pretty brightly outside.
Thank you for your time, Mr. Geller. I pass the witness, Your Honor.
Okay, Ms. Forster, do you have a cross-examination for this witness?
I do, Your Honor.
You may proceed.
Thank you. Good morning or afternoon, maybe where you are, Mr. Geller.
Good morning.
You're the owner of Chimes Department Store.
I am.
You've been doing that for 10 years.
Yes, ma'am.
The store has been in its current location since 2005.
Yep,
Want to talk about the back of that store? There's an exit there.
there is. Yeah, the loading dock.
When you moved in, that loading dock, it wasn't a loading dock, right?
Correct. Yeah, it wasn't being used as one.
It had a railing around it.
Yeah.
You had that railing taken out.
Yes.
That's when you started using it as a loading dock.
Yeah. For all our shipments that we're getting in every day, it just made sense.
So that's when you started using it as a loading dock.
Yeah.
But you kept using it as the way for employees to take out trash
Yeah.
and as the only place where they could smoke on the premises.
On the premises. Yeah.
I'm going to show you Exhibit 3. This is a photo of that back landing after that railing was taken out.
Yes, it is.
You can see here, I'm circling in red a hole on the top step, right?
Right.
I'm circling in red a hole on the bottom step, right?
Yep.
That's where the railing used to be.
Correct.
You could have patched up those holes, couldn't you?
I suppose so. Yeah.
You didn't.
No, ma'am.
You could have asked your landlord to patch up those holes.
Objection, Your Honor. May I be heard outside the presence of the jury?
You may.
Your Honor, we object under Rule 401. This is irrelevant.
Okay, Ms. Forster, response?
Yes, Your Honor. This is relevant because the fact that Mr. Geller or Chimes could have asked their landlord to take a simple step to make this area safer, well, that plays into their duty of ordinary care. That's why it's relevant.
Ms. Appler?
Your Honor, we're not contesting that we had a duty as the owners of this store to get into the relationship with the landlord and whether or not we had a duty to tell a landlord. We're not contesting ownership of this store or control of this store. Whether or not he contacted the landlord is irrelevant today.
I'm going to overrule the objection. Ms. Forster, you may proceed.
You could have asked your landlord to patch up those holes.
Yeah.
You didn't.
No.
Thank you, Ms. Smith. I want to talk about the lighting on that landing. And there was an outdoor light on the outside wall of that building,
Yeah.
but employees couldn't use that light.
No.
As you told us, the switch wasn't in your store.
Correct. It was in the one next door.
Now, you could have installed a switch for that light inside your store.
Yeah, probably.
You didn't do that before January 23rd.
No.
Let's talk about other ways you could have provided light. You could have added a lamp outside on that landing.
Sure.
You didn't.
No.
You could have left a flashlight by the door for your employees to use.
Yeah, or they could, use the flashlight on their phones.
Sure, but they're at work, aren't they?
Yeah,
So you could have offered that to them.
sure thing.
You didn't.
No.
Jordan Gilmore wasn't even the first of your employees to get hurt on those steps, was he?
Objection, Your Honor. May I be heard outside the presence of the jury?
You may.
Your Honor, this is improper character evidence and substantially more prejudicial than probative under Rule 403.
Okay, Ms. Forster, response?
Yes, Your Honor. This isn't improper character evidence because what it goes to show is that those steps were dangerous and the defendant knew about it. 404, the federal rule that applies to character evidence, involves a character trait of a person. The steps are not a person. And Your Honor, some of the exceptions in 404B apply. In particular, knowledge, that the defendant knew about the risk and chose to do nothing. I'm happy to cover, I believe it was 403 as well, if Your Honor would like.
Yeah, why don't you go ahead and do that?
Yes, Your Honor. The probative value of this piece of information is extremely high because it goes to show that a decade before Mr. Gilmore was ever hurt, someone else was hurt. The defendant specifically said that they needed to add lighting and they chose not to. Now that is crucial to demonstrate that the defendant understood the problem, which is one of the elements in today's case, and that they did nothing about it, which is another element in today's case.
Okay. Before I turn it over to Ms. Appler for her response, I take it that your position is the accident that occurred in 2010, was it, was substantially similar in mechanism to the way your client was injured. Is that accurate?
That is accurate, although we don't think it's necessary, but it is accurate.
Okay. Ms. Appler, what is your response?
Your Honor, as to the 403 argument, at this point, the employee in the incident that Ms. Forrester is referring to that occurred 10 years before is not substantially similar. And we believe that they're using this as propensity evidence to conflate those two issues. Now, we don't have this employee in court today. We can't confront this employee and ask him about the situation. They're attempting to backdoor in propensity evidence, which is essentially launching two separate complaints of negligence against Chimes. And that is substantially more prejudicial than it is probative.
Okay. Thank you both for your argument. Ms. Appler, I understand your concerns, and I think they're valid concerns. Here's what we're going to do. I'm going to allow this evidence in, but I'm going to instruct the jury that they're only allowed to consider it to determine whether or not the defendant had notice of a problem with the loading dock and or stairs. They're not to consider it to determine whether or not the defendant was negligent on this occasion. Okay?
Understood.
With that instruction constructively given to the jury, the objections overruled. Ms. Forrester, you may proceed.
Mr. Gilmore, I'm sorry, Mr. Geller. Mr. Gilmore wasn't the first person to get hurt on those steps.
No.
In 2010, one of your other employees tripped on those steps.
Yeah, one employee, one time.
You were the owner back then.
Yeah.
You know that your company took an incident report.
Yeah.
That incident report was taken by one of your employees.
I believe so, yeah.
It explains what happened.
Yeah.
I'm going to show you that report constructively outside the view of the jury. This is Exhibit 14. Now, I know this might be a little hard for you to see. We're going to blow up part of it in just a second, but before we do that, and feel free to use your own materials, this is on page 164. This is a fair and accurate copy of that report, isn't it?
It looks like it, yes.
Plaintiff offers Exhibit 14.
Any objection to Exhibit 14?
Yes, Your Honor, I stand by my prior argument of 403 and would also object to hearsay.
Okay. Your 401 and 403 objections to the exhibit are noted and overruled. Ms. Forrester, please respond to the hearsay objection.
There are two layers of hearsay within this document. There's some hearsay within hearsay, so I'll take both levels one at a time. First, there's the first level, the face of the document itself. This was a document that was prepared by an employee of the defendant, and so it's admissible as a party opponent statement under 801 D2. Now, the second layer of hearsay in this document is that there are statements in this document from two people. One is April Nardini, who is a manager and employee of the defendant. The other is Jason Stiles, who was the employee who got hurt, again, also an employee of the defendant. Those statements, there are two separate and independent bases for the admissibility of those statements. One, first, is that under 801 D2D, they are statements of an agent or employee of the party opponent. And then second, those statements are admissible not in addition to being admissible for their truth, they're also admissible just for the notice, that the same reason that Your Honor is allowing this evidence, to show that the defendant knew that this was happening.
May I respond briefly, Your Honor?
You may.
While what Ms. Forrester is saying may be true about who these employees are, none of that foundation has been laid yet. So in order for that hearsay exception to apply, Ms. Forrester does need to lay that foundation.
Can I respond to that?
Certainly.
As Your Honor knows, the federal rules provide in Rule 104A that Your Honor can decide any preliminary question of admissibility relying on evidence that hasn't been offered or isn't even admissible.
I understand all that. And, Ms. Appler, I think that you are being a good advocate for your client and making sure that the predicate is laid. But let me just ask you, are you disputing that that the two folks that are mentioned and have statements within this document were employees and or injured persons at this prior incident?
We're not disputing that they're employees, Your Honor.
Okay. I think your objection as to the statements by the allegedly injured employee constituting hearsay within hearsay, I think those are valid concerns. I think that they are admissible, but only for the limited purpose of showing notice. If you want me to give an instruction to the jury to that effect,
Yes, Your Honor.
I can do that. Okay. We will constructively instruct the jury that they're not to consider those statements by that particular person for the truth of the matter. They're only to consider them for purposes of notice on the part of the defendant of some alleged defect on the back stairs. The rest of your objections, Ms. Appler, are overruled. And exhibit, is it 14?
Your Honor.
Exhibit 14 will be admitted. Okay. You may proceed, Ms. Forster.
Sure. We're going to publish to the jury. I'm going to blow up the last paragraph of this exhibit, or of this page of this exhibit. I'm going to ask Ms. Smith to start highlighting from "as I was walking down the steps." I'm going to read it aloud. As I was walking down the steps, I slipped on what I think was loose concrete, and I fell face first onto the ground at the bottom of the steps. Mr. Geller, after you had notice about that loose concrete, you didn't make any effort to clean up any loose concrete, did you?
Not that I recall.
I'm going to keep reading. There was nothing for me to grab onto, so I couldn't stop my fall. After you had notice of this, you didn't add anything for employees to grab onto.
No, 'cause if we added a guardrail, then we wouldn't have a loading dock anymore. And so, weighing those two, we kept the guardrail since, people rarely got hurt if they ever went on the back.
You didn't add a handrail on the side of the building, did you?
No,
You didn't add anything to grab onto.
no.
We're going to go to the next page. We're going to enlarge the bottom portion of this. Mr. Geller, this says for chimes use only, right?
At the top, yeah.
At the top, it says to be filled out by the supervisor or manager.
Yes.
I'm going to highlight the bottom question and answer, and I'm going to read it.
Okay.
Are there any steps that should be taken by chimes to help prevent such injuries in the future? Make sure there is adequate lighting on the loading dock. After you had notice of the lighting issues, you didn't make any effort to change the lighting on the loading dock.
Right. I think the lighting there is adequate.
You didn't make any effort to change it, yes or no?
No.
Thank you. Nothing further.
All right, Ms. Appler, do you have a redirect for this witness?
Yes, Your Honor.
You may proceed.
Now, Mr. Geller, opposing counsel just asked you about that incident report. How long ago did this event supposedly occur?
It was about a decade ago.
And after that report, about a decade ago, up until the plaintiff's accident in January of 2019, did you and your employees continue using that loading dock?
Yeah.
How often would you say?
Every day. We get shipments every day. People take smoke breaks every day. People throw out the trash every day, multiple times a day. If we have a particularly dirty store that day, and those thousands of trips out the loading dock. Never had another problem.
So during that 9-year period, did any of your employees injure themselves out on that loading dock?
No, it was perfectly safe.
During those 9 years, did you receive an OSHA violation?
No, ma'am.
What about in 2010 when this incident supposedly occurred? Did you receive a violation then?
No, ma'am, because those stairs at loading dock, it's safe.
Thank you, Mr. Geller. Nothing further, Your Honor.
Okay, Ms. Forster, do you have any recross for this witness?
No, Your Honor, no need.
Okay, may the witness step down.
Thank you.
All right. Ms. Appler, you may call your next witness.
Your Honor, at this time, with the court's permission, the defense seeks to admit portions of unavailable witness Peyton Holt's prior deposition testimony. And this was taken on August 1st of 2020. And if my second chair, Ms. Letko, can come read Mr. Holt's answers while I ask some questions.
Certainly.
Now, directing the court and opposing counsel's attention to page 2 of the deposition, which is page 110 of the record, beginning at line 11. What do you do for a living?
I am a compliance, safety, and health officer with the Occupational Safety and Health Administration.
What does the Occupational Safety and Health Administration, or OSHA, do?
OSHA is the government agency that's responsible for making sure that workplaces are safe for the employees that work there. So we provide information, training, and assistance to employees and employers to try to make workplaces as safe as possible and to make sure those workplaces are in compliance with OSHA regulations and standards. We are all about employee safety.
And what do you do at OSHA as a compliance, safety, and health officer?
I'm one of the people from OSHA that goes out and inspects workplaces on a regular basis to see if that workplace is in compliance with OSHA standards.
What happens if a workplace doesn't comply with those OSHA standards?
Well, there are a lot of potential implications, but at the very least, it would result in a citation for any violations that we find. Then the employer would have a chance to correct the issues that we find. Then if they fail to take corrective steps, we might issue fines.
Moving on to page 5 of the deposition, page 113 of the record, line 16. Why did you inspect the Chimes department store in Waco back in 2018?
It was just a regularly scheduled inspection. We do that all the time. Just show up and do an inspection.
So were there any complaints that led to this inspection?
Not that I'm aware of. I went out there because it had been a while since we'd been out there. That's it.
During that inspection, what were you looking for?
At the most basic level, I'm looking for any kind of condition at the workplace that might be dangerous to the employees working for Chimes.
How do you determine if a condition is dangerous?
Well, if a condition on the premises doesn't comply with the standards under the OSHA regulations, then it would be dangerous and that would necessitate a citation.
Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
Did you inspect the area behind the store where there's a little landing area and some steps?
Yes, I did.
Why did you inspect that area?
At the beginning of every inspection, I ask the representative for the employer to outline for me all the areas where their employees work. When I asked that question to the manager at Chimes that day, they told me that the employees regularly worked in that area behind the store and took smoke breaks there. So once I had that information, I made sure to include it on my list of areas to inspect.
When you went out there, what did you notice about the steps in that landing area?
Well, at first I was a bit alarmed because there were some pretty obvious issues.
Like what?
Well, there were stairs in a landing area, but there were no guardrails anywhere. Plus the concrete on the edges of those steps and that landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems.
There were such obvious safety issues. Why didn't you issue any citation?
Well, as I said, I got pretty alarmed, so I asked the manager that was walking around with me during the inspection about the fact that there were no guardrails and about that cracked concrete. The manager told me that there used to be guardrails, but they were removed because Chimes used that landing area as a loading dock.
Why does that matter?
Because loading docks don't have to have guardrails.
How do you know that?
Because OSHA says so.
Directing the court's attention and opposing counsel's attention to page 8, page 116 of the record, line 20. Is there any OSHA regulation that does specifically discuss loading docks?
Yes, 1910.28B13 clearly states that guardrails aren't required on loading docks because they aren't feasible. You can't very well load something onto the dock with a bar in your way.
And directing the court's attention to page 9 of the deposition, page 117 of the record, line 12. Was this area behind the store exclusively used as a loading dock?
No, it's my understanding that employees also went out there to throw trash in the dumpster and to take breaks. And it's certainly possible that employees went out there and did other things as well, but I don't think that matters.
Why not?
Well, just because an employee goes out and sits on the edge of a loading dock and eats a sandwich doesn't make that loading dock a diner. The key thing here is that Chimes used this area as a loading dock. That's what matters.
Thank you, Your Honor. We pass the witness at this point.
Okay, Ms. Forster, do you have any portions of this witness's deposition which you would like to read in cross?
We do.
You may proceed.
Starting on page 11, line 16 through page 12, line 3. Did you ever inspect that area behind the store at night?
No, only during the daytime.
Did you notice a light out there while you were doing your inspection?
I did. You'll see it noted in my report.
Did you ask the manager about that light?
I did, like you can see in my report.
And what did the manager say?
The manager told me that they always turn on the light when somebody goes out back at night. So that seemed good enough for me.
Moving to page 10, lines 5 through 14. Do you disagree with the assessment of your boss in this email?
No, I don't. I am fairly conservative when it comes to issuing citations. Look, I obviously believe that workplaces need to be safe for employees, but that doesn't mean the government should be draconian in enforcing those regulations, especially in times like these when it's hard enough to find a job or a place to work. So maybe I'm a little more lenient than other inspectors. That's certainly possible. But I do my job and I do it well. And we talked about this issue and it was all good. It's not like I've been fired or anything.
Thank you. We have nothing further from this deposition.
Ms. Appler, are there any portions you would like to read in and redirect?
None, Your Honor.
Okay, then you may call your next witness.
Your Honor, at this point, the defense rests its case.
All right. Ms. Forster, do you envision putting on any rebuttal case today?
I do not, Your Honor. Plaintiff is ready for closing arguments, although maybe it's a good idea to take a break first.
For the record, before we do that, do both sides finally rest and close the evidence?
Plaintiff
Yes.
does.
Okay. In that case, I think a 5-minute break would be a good idea.
Your Honor, apologies. Prior to our break, I would like to renew my motion that I made.
Understood. It's going to be denied, and we will proceed to closing arguments. Let's plan on being back here at 11:55 Central Time, and we will do a time check, and then we will close. Okay?
Sounds good.
See you then. All right, is everyone ready to proceed with closing arguments?
Yes, Your Honor.
Yes, Your Honor.
I have 16 minutes remaining for the plaintiff and 21 minutes remaining for the defense. Does that sound acceptable to everyone?
That's what we have as well.
Okay, perfect. Then if there's nothing else to take up, Ms. Forster, you may start your closing argument whenever you are ready.
Thank you. Simple steps. The defendant could have taken simple steps to keep its employees safe, but it didn't. Today, you heard about the Chimes department store here in Waco. You may have seen the front of that store, the glistening front doors, the clean aisles. But folks, today you heard about a different part of that store. You heard about the back area, an area that they make sure customers don't see. You heard about those crumbling concrete steps, the peeling paint, the missing railing, the door that swings out into the walkway, and the light that no one can figure out how to turn on. You heard that employees of that store were required to use these steps, to use that area. They had to use these steps every time they were going to take out the trash. They had to use these steps every time they were going to go smoke a cigarette on their break. These steps were an accident waiting to happen. And on January 23rd, that accident did happen. You heard how it happened. You saw that photo. You saw the aftermath. Simple steps. Simple steps could have prevented it, but the defendant didn't take them. Folks, you are here today because of the defendant, because of their actions. And the job that you are given today is to answer one simple question. Was it the defendant's negligence that caused Mr. Gilmore's actions? I want to take a moment to talk about something called the burden of proof. Now, the burden of proof, that's how much we had to prove our case by. And it was the plaintiff who had the burden. We had to prove every element of negligence by a preponderance of the evidence. That means the greater weight of the credible evidence, or even more simply, more likely than not. 3 things we had to show you. If we showed you those 3 things were more likely than not, then the defendant is liable. Now, here are those 3 things. We had to show you, first, that the defendant created an unreasonable risk of harm. Second, that the defendant knew or reasonably should have known of the danger. And third, that the defendant failed to use ordinary care to protect its employees. Now, as I said, we had to prove each one of these, so we are going to talk about each one of these. We're going to start with number 1, an unreasonable risk of harm. Well, folks, for starters, you saw those photos. You saw the crumbling concrete, the lack of a railing, the door that's in the walkway. It doesn't take any more than your common sense to realize that's unreasonable, especially in the dark at night when there's no working light. But you don't have to rely on just your common sense if you don't want to. Because today you also heard that those stairs weren't just dangerous, they were also a violation of the law. You saw those laws. Laws that require railings to be provided on the open sides of all exposed stairways. Required stairways to have handrails on each side. Another regulation that requires that the means of egress, the way you get out of a building, be illuminated at all times, that it be lit up at all times, that people are inside the building. Now, it doesn't take an expert to read those laws, to look at those pictures, and to realize that they didn't follow the law. It doesn't take an expert, but we brought you one anyway. Kelly Danes, a professional engineer. You heard from her deposition. You heard what she said. You heard her words, and I quote, "Honestly, I just don't know what the defendant was doing here." In her words, just a few simple steps could have made this area so much safer. Now, the defendant wants to quibble about those regulations. They say, well, we used it as a loading dock. Remember, it wasn't built as a loading dock, but we used it as a loading dock, so maybe the railing regulations don't apply. Well, folks, you heard Ms. Danes tell you that they did, but we can put that aside. Let's go to the lighting issue. Now, I expect that in a moment they're going to get up and they're going to tell you, well, that area was adequately lit. But folks, remember that today they have relied so much on that OSHA inspector, Perry Hayden, on the fact that that inspector came to their store a year before this accident and told them that there were no violations, that they were in the clear. But I want you to remember the part of that deposition that we made sure you heard, that the only reason Perry Hayden said there are no violations is because when Perry Hayden asked the defendant's manager, does this light out here work? The defendant's manager said, oh yeah, we turn that on every time someone is outside. That's not what Reese Geller said. That's not what Jordan Gilmore said. The testimony you heard was that that light had never once been on. They couldn't even turn it on. The only reason that they got through that OSHA inspection, folks, is because that inspector did not have the full truth, because their manager made sure not to give it to them. We know they broke the law. And it's important to remember what the law is, what it represents. It represents a consensus in our society about what is safe, about the bare minimum that we expect everyone, employees, business owners, to do. They didn't do it. That's unreasonable. That's how we proved that first element. So I want to go on to the second one. We had to show you that the defendant knew or should have known about the risk. And all you need to remember about this is how many times they were told about the risk. They were told about the risk in 2010, when you heard they were told that someone else fell down those stairs, that they had notice of that. They said in 2010, in their own manager's words, that they needed to make sure there was adequate lighting on the loading dock, in their own words. That's how you know they knew. But it wasn't just 2010, because Mr. Gilmore came before you and told you that he told them about the lighting issue years before he got hurt. And they just said, well, there's nothing we can do. And then he told them one more time. After his fall that day, he went in, the first thing he did was tell his manager, and his manager said, oh yeah, those stairs, we should have fixed them a long time ago. I've told the manager about it. I'm sorry, I've told the owner about it. The person you heard from, Reese Geller, I told the owner about it. I guess there are bigger problems to fix. That's how you know. They knew. So we can move on to that third element. Did the defendant fail to use ordinary care to protect its employees? Ordinary care. What a normal person would do. What a normal situation would look like. Folks, I want you to think about how many sets of stairs you've seen that don't have a railing, that don't at least have a handrail along the side where the wall is. Bet you can't think of too many. That's because that is an ordinary step to take. I want you to think back to defense counsel's opening statement They told you not all accidents are negligence. Sure. We're human. Sometimes you stub a toe. Sure. Not all accidents are negligence. That's true. But when that accident is caused because you are forcing your employees to walk up a dark, crumbling staircase, to navigate around a door in the dark, when that accident happens because of those conditions, that's not the same thing as stubbing a toe. They failed to use ordinary care. They failed to take any one of those simple steps. You heard what those steps could have been today. They could have had a railing, could have just had a handrail. They could have installed a light switch. Maybe they don't want to do any construction. They could have left a flashlight by the door, folks. That's how simple it would have been. But they didn't lift a finger. I expect that in a few minutes, they're going to come before you. They're going to try to reframe what their responsibility is. See, they're the employer. They're in control of this area. They have a duty to look out for their employees. But when they come before you in a moment and they tell you everything in that area was just fine, everything was safe, I want you to remember that what they are telling you here in court today, that is not the same as what they said themselves 10 years ago, when they said they needed to make sure there was adequate lighting on those stairs. Why are they not admitting to their mistakes? Why are they not telling you the same thing? Why are they giving you a different story than their own words 10 years ago? The answer's obvious. They don't want to take the blame. They don't want to admit that they are the reason that Mr. Gilmore ended up with 28 stitches in his knee. But they are the reason. The reason is those simple steps they should have taken. Because they didn't, they were negligent. Find them liable.
Okay, thank you, Ms. Forster. Ms. Appler, would you like to give a closing argument?
I would, Your Honor.
You may proceed whenever you're ready.
May it please the court. Counsel, members of the jury, accidents don't automatically mean negligence. That's what today's case was really about. Now, at the start of today's trial, I talked to you about things in our lives that have become automatic. Shopping, even driving from place to place, paying our bills. Our lives are now controlled by technology, by convenience. But today you learn that that doesn't apply to everything. Not everything in our lives is automatic. The law is not automatic. Justice is not automatic. And they shouldn't be. Both of those things require a careful deliberation of the truth, of the facts, of the evidence. And the plaintiff today wants you to make those things automatic. They don't want you to look at the facts. They want you to look at this accident and automatically point the finger. Point the finger at Chimes department store. They want this accident to automatically mean that Chimes was negligent. And you now know that that's just not the truth. I want you to remember why we're here today, members of the jury. The plaintiff brought this negligence claim, not us. And that means that they had the burden today. They had to prove to you that Chimes was negligent by a preponderance of the evidence. And that burden remains with them today. It never shifts to our table. And you now know that it's just something they failed to do. Because in order to prove negligence, to meet their burden, they had to prove to you that Chimes breached their duty of ordinary care and that this breach caused the plaintiff's injuries. I promised you earlier today that at the end of this trial, I'd come right back here before you and I'd walk you through piece by piece, element by element, how the plaintiff failed to do their job today. So let's do that right now. But in a moment, the Honorable Judge Yelverton is going to come before you, and he's going to give you a set of instructions. And these are called your jury instructions. They'll tell you exactly what to do when you go back to deliberate. And inside them, the Honorable Judge will explain the law to you. He'll tell you that the plaintiff had to prove 3 things to establish negligence today. So let's take a look at those instructions. First, that the condition in question posed an unreasonable risk of harm. Second, that Chimes Department Stores Incorporated knew or reasonably should have known of the danger. And finally, that Chimes Department Stores failed to exercise ordinary care to protect Jordan Gilmore from the danger by both failing to adequately warn Jordan Gilmore of the condition and failing to make that condition reasonably safe. And they had to prove every single one of these elements to you today. And you now know that they did it. So let's walk through how. Let's talk about that first one. First, they had to show you that a condition of Chimes Department Store posed an unreasonable risk of harm. And they want you to automatically believe that the lighting on the loading dock, the lack of railing, the stairs posed unreasonable risks. But you now know that none of those things are true. So let's talk about them one by one. Let's start off with the lighting. Now, you heard from multiple witnesses today that there was, in fact, lighting on that loading dock. It might have been dark outside on January 23rd, but you heard that the plaintiff and his coworker were illuminated that night. When they went out for their smoke, when they left that back door open, this back door that leads to the stockroom with all those giant fluorescent lights, well, you can see in this picture, those lights give off an awful lot of light, even in the daytime. And those lights were on that night. The plaintiff admitted to you on cross-examination that even with that door open only a few inches, even with his coworker standing in front of it, he could still see the stairs. In fact, he could see them well enough to walk down them and back up. We also talked to him about those doors. And you saw that those doors, well, they opened beyond just a few inches. Now, Chimes had their lights on shining bright right behind those doors so that they could be opened up, that they could release that light onto the loading dock and onto the steps beside it. And the plaintiff told you he had been out on that loading dock thousands of times, 4,000 times, many of those times at night. And he had never had any issues with the lighting then. He even had a flashlight on his phone, and he told you he didn't think it was necessary. He could see just fine. Members of the jury, just because Chimes didn't have a giant floodlight out back does not pose an unreasonable risk of harm to any employee, especially not to the plaintiff. So let's talk about the lack of the railing. The plaintiff wants you to believe that the lack of a railing posed an unreasonable risk of harm, but that's not true either. You heard from multiple witnesses today. It's impractical for loading docks to have railings. It's not required by the law. The plaintiff himself told you, even if he didn't want to admit it, he had never complained about there not being a railing because it would make loading deliveries near impossible for everybody involved. Look at this delivery picture. Now, the railings were taken off of that platform to make it a loading dock. Think to yourselves, what if there were railings attached in this picture? Well, it'd make that delivery incredibly difficult. And the owner, Reese Geller, told you himself. He was just trying to make his business run smoothly, to get new shipments onto his shelves, to be faster for his customers. He runs a small family business, a business that's still growing. He was just trying to keep up with the demand. He wasn't required to have a railing installed on this loading dock. Now, the plaintiff told you himself, those stairs. He had gone up and down those stairs thousands of times over the course of 10 years. and he never had to use a railing. He barely even noticed that there wasn't one attached. That's not an unreasonable risk of harm. They haven't proven that element. So let's talk about the second one they had to prove. They had to prove that Chimes knew or should have known about the dangers of those conditions. But they haven't done that either. Now, on cross-examination today, you heard the plaintiff. He couldn't remember what he told management. The plaintiff wants to say that Chimes had notice, but he couldn't even tell you in court today what he told them. How can you take what he says at face value when he was mistaken about something so vitally important to today's case? Members of the jury, it's not a question. We do know what Chimes knew. Yes, Chimes knew that they didn't have a railing attached. They knew they didn't have a gigantic floodlight in the back of their store. And that's because those conditions aren't dangers. They knew a railing wasn't necessary and was impractical for their business. And they provided those fluorescent lights. How could they have known of these two dangers when they don't even exist? A plaintiff talked to you today about some supposed incident that happened back in 2010. And their case today hinges on this supposed previous incident. They say that it provided Chime with notice. But think to yourselves, this prior incident gave notice of what? It was one accident. An accident that we can't even ask the employee who was working at the time about. We don't know what he was carrying at the time, whether he was wearing proper shoes. Members of the jury, regardless of what he was doing, regardless of what he was wearing, accidents happen. Just because someone trips on the floor of a business doesn't mean you redo the entire flooring. Just because someone bumps an elbow on a counter doesn't mean that you call a contractor to go and rip it out. They've failed to meet that second element. Finally, they had to prove that Chimes failed to exercise ordinary care to protect the plaintiff from these dangers. And once again, they haven't done that. Because Chimes did exercise ordinary care. Their property didn't have any dangerous conditions. It was even inspected by a federal agent. And you heard his testimony today. He told you he didn't cite any violations of any federal law or statute because, simply put, there weren't any. Chimes complied with the law. They did what a reasonable company would do. They provided enough lighting. They provided a recreational space for their employees. And they followed the law. They built that loading dock in accordance with federal safety standards. They exercised ordinary care. As a matter of fact, there were no dangers to protect Jordan Gilmore from, members of the jury. That just goes to show they couldn't meet their burden today. We've shown you that. Now, as I said at the beginning of today's trial, it's easy to jump to conclusions in a case like this, to want to point the finger because somebody got hurt, to try to place blame. Because we're all human. Now, we said sometimes we stub our toe. Sometimes we hit our elbow on the edge of a table. We lose our footing. But here, the plaintiff is looking for somewhere to place blame. They don't see this as an accident. They want an answer for Mr. Gilmore's injuries, and it's natural for them to want that. But sometimes in accidents like these, no one is to blame. Accidents happen. And this case showed you that accidents like what happened to Mr. Gilmore don't automatically mean negligence. We're fortunate enough that the law in our democracy is one area where few things are ever automatic. It's built around that slow, careful deliberation. That's why you're here today. Now, in a moment when the Honorable Judge Yelverton comes before you, he's going to instruct you on the question that you have to answer as jurors today. Did the negligence, if any, of Chimes Department Stores Incorporated proximately cause the occurrence or injury in question? You now know the answer. No. Chimes did not proximately cause Mr. Gilmore's injury. You can write that on the line provided. We all know that accidents happen. but that oftentimes accidents aren't victimless. You can feel sorry for Mr. Gilmore. You can sympathize with the pain that he's gone through. But accidents don't automatically mean negligence. Now, as jurors, it is your job to put that sympathy aside. Put those emotions aside. Your job is to apply the law, to look at the cold, hard facts. Look at the truth. And that's why we ask you, after your careful deliberation, to return the only verdict in this case that is supported by the truth, by the evidence, and demanded by law. We ask that you find Chimes Department Store not liable. Thank you.
Okay, Ms. Forster, would you like to offer a rebuttal?
I would.
You didn't reserve any specific amount of time, but I think 2 minutes would probably be appropriate, don't you?
Yes, Your Honor. I believe I have about 4 minutes remaining. If I could take 2 to 3, that would be great.
Okay.
Thank you. It's not that their negligence is automatic. It's that it's obvious. It's obvious because they made employees go down those crumbling stairs without a railing, without even a handrail, in the dark. They didn't check to make sure that light was working. They knew it wasn't working, and they still made them do it. Now, their best attempt, their best argument for why there was enough lighting back there was, well, the employees could open the doors. The light from inside, that'll go out in the back, make it easy enough to see. But folks, you heard that's exactly what Mr. Gilmore tried to do. You heard what happens when you open that door. You heard that he's trying to come up those steps, his coworkers standing on that landing, holding that door open in the wind, trying to give Mr. Gilmore the only light he can, leaving him 12 inches of crumbling concrete. They left Mr. Gilmore between a rock and a hard place. They left him in the dark. And in the dark, he got hurt. Now, Ms. Appler, she says, well, just because we didn't have a giant floodlight, thank you, Ms. Smith, just because they didn't have a giant floodlight out there, well, that doesn't mean we're negligent. Well, folks, why not? Why not have a floodlight? Why not have one single light, one single lamp, anything? Why not fix that light switch? Is that asking too much? For them, it is. For them, it's asking too much because throughout today's trial, they have made clear what their priorities are. Their priorities were to use that back landing as a loading dock, to get merchandise in, to make money. They told you at the beginning of this trial, they wanted to project a clean image to their customers, make it warm and welcoming for their customers. What are they sacrificing for their customers? They're sacrificing their employees' safety. That's negligent. Find them liable. Thank you.
Thank you, Ms. Forster. That concludes the presentation of evidence and argument. At this point, the case is submitted to the jury for your determination. Please fill out your ballots and submit them to the tab room via email, and then we can give some brief comments to the competitors. Jason, are you ready to get some comments?
I'm ready whenever.
Why don't you go for it?
Well, the first is to be careful calling Judge Yelverton honorable. But
Careful, I'll sanction you.
I think y'all both did great. I never got to participate in this particular deal, but did get to help run it a couple of years, and I know how crazy it is to get this at the last minute and throw stuff together. And y'all both did a great job of putting that together. Just little nitpicky things more than anything. Both of you made promises in opening. Those can backfire on you real fast. So be careful when you're doing it. I think you both did well with them, but just keep an eye on, the typical overpromise, underperform type situation. Make sure you're actually going to be able to do it. Ms. Forster, your opening line or opening question to your client, tell us about yourself, and then letting him go narrative. That is one of the scariest things you can do. And it is, to me, seems better advocacy to walk him through some of that stuff rather than give him the chance to just talk, because you never know what's going to come out of their mouths, no matter how many times you help them. I have them all on the left side, so we'll go with Ms. Forster first. In your direct, you used accident a lot. Feeds right into the defense's theory here. To you, it's not an accident. It was their problem. That we should have seen this coming. It didn't come out of nowhere. So just be careful using that word as you're going through. On closing, I thought you did a great job anticipating what we were going to hear from the defendant. And I apologize, my almost 4-year-old came running through here right in the middle. So if I missed part of it, then forgive me. But on your rebuttal, I thought the automatic versus obvious was great. We knew that was coming because she'd used it in her opening. So anticipated even more, bring that into that first part of your closing to make sure. But I think you did a great job putting all this together. The evidence was, I think, exceptional. Ms. Appler, in your opening, you talked about pay close attention to the evidence. I think that can be a real but get specific with it. You know what's coming in. When you hear this person, I want you to ask yourself these questions. Set them up even more than just pay attention. Sometimes I can't read my own writing. The impeachment deal, when you went into the lighting and stuff, that didn't seem like the big important part there. You had him dead to rights. Go straight to that line. Don't worry about the rest.
I had the wrong line number written down.
Okay.
I went to 9 and I was like, oh no, okay.
Okay. that I get it then. And then the only other thing is on the defense, and I do mostly defense work, and in fact, I do a lot of employee injury for big groups or big companies out here. So said to have happened, where it was said to have taken place, we all know he got hurt. The question is, whose fault is it? So be careful blaming or making it look like he's lying about this situation. It happened. Just embrace that and go forward. But I thought both of y'all did a great job, especially working with a medium that us old folks have had to figure out on the fly and sometimes don't do so well with. So good job.
All right, thanks, Jason. Ms. Sheridan, you want to go next?
Sure, I'm happy to. So this is my second round of judging an all-girl round, and Judge Yelverton heard me say this yesterday, but you make my heart happy. I am happy for the future of our profession, and I'm particularly happy for the future of women lawyers when I observe you two. So thank you for that. I'm a family lawyer. I am board certified in family law, so I haven't done any of this stuff since I was a Baylor lawyer with, the plaintiff and defense or anything. So it's always kind of fun for me to get drawn back into other stuff. even though I think what I do is the real world, because no matter how bad the economy or anything happens, people are still going to fight over kids and property. And so that's why I have a job. So just a few things I would say to you, and these are like the nitpickiest of things, because both of you were absolutely, you're both very comfortable in the courtroom. I know it's a virtual courtroom, but I can only presume that you would be equally comfortable in a real courtroom. You're both delightful. And so again, take this with a grain of salt, because I don't have a lot of criticism, because you both, it's one thing to be coached, but there's also something to have an innate ability. And I think both of you are extremely innately capable. For me, a big thing for me is drafting, whether it's drafting your pleadings, drafting your statements, whatever. So my biggest thing to you would be to say that words matter. Words matter, and how you phrase things, what words you choose when you are, whether it's in direct or cross, opening or close, words matter. Don't get so hung up on legalese. I understand that each of you need to either find the plaintiff or the defendant liable or not liable, but there are other ways of saying liable that speak louder to a jury or even a judge, because believe it or not, judges are people too, and they have feelings and that sort of thing. So I don't think that you need to be wedded to the word liable. I think something that would have been much more powerful for both of you is accountable. And accountable means liable. You can still argue from the charge, and the jury's going to know that they're going to find someone liable, but accountable to me has a greater impact. I think both of you missed some significant hearsay objections, particularly the one where Miss Appler, I would have been jumping up and down, and maybe I missed an agreed something or whatever, but when Ms. Forster talked about and asked the question, that the first thing that the supervisor said in response to the complaint was, "Oh, I guess we should have fixed that." That's like the hugest.
It's a statement by a party opponent, so it's kind of a loser. If I make it, I'm going to lose automatically.
I would still make it, because that, yeah, I mean, that's huge. So another one, I can't remember who did this. Someone asked the question of, so it must have been Miss Forster. So Miss Appler asked the question, did you think there was sufficient lighting out there by, the main guy? The way that question was phrased, I think you missed a huge objection, because he's not qualified to make that if it was adequate. Now, had she asked it in a way of, did you feel there was adequate lighting, blah, blah, blah. But I mean, that was a huge objection to miss. I felt like both of you missed some objections. Now, having said that, I think both of you were very good at listening and using each other's words and testimony against each other. And that is so critical, to not just be wed to a script and just stick to your stuff. So I appreciate that y'all both, I felt like you were both listening. Ms. Forster, I would suggest to you, and you please forgive me, I am a Baylor lawyer, and I was taught by the devil to argue from the charge. I think when you're the plaintiff for it all, you need to bring the charge up and tell the jury exactly what you want them to do on the charge, and not just make the argument. I think Ms. Appler, you did a good job of that, because you did bring up the charge and say what you wanted the jury to do. But I would say, Ms. Appler, I'm not sure I would say justice is not automatic. that kind of didn't sit well with me. In our current world, particularly with the pandemic and everything, I think everyone sort of needs to believe that justice is automatic. So I'd find a different way to phrase that. I mean, I get what you're saying, but saying that justice isn't automatic was a little problematic to me. Maybe you can find another way to convey what you want to convey without saying justice isn't automatic, because I think we all need to feel, especially as lawyers, that justice is sort of automatic. Anyway, but I thought you were both brilliant, and it was a delight to watch you. So thank you.
TJ, you want to go next?
I can. Can y'all hear me okay?
Yep.
I'm having to use headphones because my 2-year-old is watching TV. So this is my second time judging in front of the Honorable Judge Yelverton. And I'm going to say what I said yesterday, which is I never remembered when I was competing what the last judge had to say about what about my argument. So I'll try to be as brief as I can. First, a compliment to both of you. I thought specifically that the evidence objections that you did make were very well handled. As some of the other judges said, there were some things that you missed as far as evidentiary objections, but the things you did choose to fight about, both of you knew where the other was coming from. So nothing caught either of you off guard. So y'all had very good arguments on evidence at every point. And I thought the evidence objections that you did make were strategic. And so I thought the evidence was very well handled on both sides. A few nitpicky things on both plaintiff and defense. On the plaintiff's argument, I love the theme of the one simple thing. This is the one simple thing that you could have done that you didn't do. You had every opportunity. It would have been a $10 fix and you chose not to do it. I think that it should have been paired with something about profits over people. Like you should have, I kept coming back to, okay, this is a loading dock. Think how much merchandise is coming through that back door. You couldn't set aside one pallet of stuff to pay for the light. How much of that merchandise would it take to have fixed the light, right? And so I love the theme of profits over people, but I think that it needs to be paired with I love the theme of the one simple thing, but I think it needs to be paired with a profits over people theme as well to be as effective as it could be. And you said that in your last, and I think in your rebuttal, but I think it should have come out in your opening, that you should pair those things together to make it persuasive. On the defense side, I think the defense's theme took too long to unfold. Like, I understand where you're coming from, and I understand what you were trying to say with it's not automatic, we're looking for convenience, this is the hard stuff. You have to actually look at all of the evidence and be decisive. But I think it took too long to unfold. I think that if you're going for contributory negligence, which I think is a very strong argument in this case, it needs to come out in the first things that you say. This is about being responsible for your actions, right? The plaintiff went up and down those stairs 10,000 times. They only did something weird walking up the stairs once and they got hurt. It's their responsibility. It's about taking responsibility for your actions. And so I think the defense's theme, if you're going to stick with it, truncate it and try to make it a little bit more bite-sized, and then launch into your different, road mapping. And so those are the things that I have. You both did great. Very, very good job for both of you.
Miss Evance, you want to chime in and give us some critiques?
Yes. Can you hear me okay?
Yes.
There I am. Okay. Sorry, I've got my little girl with me. Yeah, going last, I agree with the majority of the comments by the other judges, what they had to say. So I'll just be very brief. I'm a prosecutor, and so I do a lot of jury trials, and visual aids are so important to keep the jurors engaged. And so I just wanted to give you both a compliment that I thought you both did an excellent job using your exhibits and using them, on Zoom, which is even more challenging, and coordinating them with your trial partner who may or may not even be in the same room with you. So just a compliment is all I have. That y'all both did a really good job with that, and I would encourage you to keep doing that in future rounds.
Great. I will go last and be brief. Let me say that, I coach 2 mock trial competitions every year, and I preside over this competition and rounds every year. And this is the best mock trial round I've seen in a long, long time. It was also one of the closest I've seen in a long, long time. So I would not be surprised if it went either way. You can both be very proud of that. Just nitpicky things. I thought both of you said things in your opening statement, which, as Ms. Sheridan said, words matter. And I think the other side could have capitalized on. For the plaintiff, you said you were describing the accident. You said he tried to jump for a clean landing. To me, that sounds suspiciously like contrib. And so I would have capitalized on that if I was the defendant. For the defense, you said this isn't a dangerous loading dock. Deliveries are still made there every day, right? Well, if I was the plaintiff, I'd write that down. And my first thing that I'd say in the rebuttal is they haven't changed a thing. Someone else is going to get hurt unless you do something, right? The only thing I have to say about evidence, and y'all probably thought that I was, cuckoo for Cocoa Puffs on my evidentiary rulings. I was trying to make it straight down the middle and call it how I would. The one thing I'll say is about this prior accident where another employee slipped and fell coming down the stairs. I think y'all both gave up the fight on substantial similarity a lot too soon. Because to me, as a judge, trying to be fair, what it comes down to is, are we talking about the same mechanism of injury? Is this something that's going to be helpful for the jury to know about? And once I actually heard the facts of the accident, the fact that he thought he slipped on something as opposed to fell off in the dark, I kind of regretted letting it in, And so I even signaled to y'all at the front end, hey, is this substantially similar? And no one wanted to talk about it really. So I would fight that a little bit more on both sides if I were y'all. The one thing I'll say about closing is I think that the defense could have gone a little bit harder on comparative fault. You have a very good theme, which is accidents happen and sometimes it's no one's fault. But I think you have to pair that with, and if it is somebody's fault, it's the plaintiff's, right? On the plaintiff side, be sure to reserve time for rebuttal. There are some judges that are just jerks and would not let you have a rebuttal if you didn't reserve time. So just don't risk it. And the very last thing I'll say for the plaintiff is we, as a plaintiff's lawyer myself, we do not have the luxury of thinking that if the jury gets confused by the charge, it's a good thing for us. So as a plaintiff's lawyer, it's almost malpractice to not bring up the charge and fill it in the way you want the jury to fill it out. I think Ms. Sheridan's exactly right on that. So I would definitely do that going forward. But great job, you guys. You're tremendous advocates. You're going to be tremendous lawyers, and I wish you good luck in the competition ahead. Okay?
Thank you so much to all of you for taking the time out of your weekend to do this for us. Even over Zoom, it really just means the world. We so appreciate it. Thank you so much.
We appreciate y'all too. And thank you to the judges, the jurors that we had today, and the witnesses and everybody else who participated. Good luck.
Thanks so much.
Well, gentlemen, good to see you again. Most of our folks will join us.
Good afternoon, Judge Harris. We meet again.
Yes, sir. How are you?
Fine, thank you.
Good afternoon, y'all. How are you doing, Judge?
All right, Mr. Kelly, how are you?
All right.
Get everybody to join us. Still missing a couple. I didn't realize till they told me today, and I guess I had let last year pass my mind, that I'm the only sitting judge now 2 years in a row participating in this thing. I guess the fact that I live here most of the time makes it easy to pick on me. So we've got we're still looking for Patrick Kelly.
I'm on here, Your Honor.
Here. All right. Oh, there you are. Yeah. Okay. There's Mr. Paul, Mr. Dow, Mr. Bernhardt, Will Moy. I see he's joining us, or trying to join us. Mr. Moy, can you hear us?
I can.
All right. So there's all of our scoring judges. Let me see if we have our council together. Lawyer Appler ready?
Good afternoon, Your Honor.
Good afternoon. And Jacques Kasimsri?
I don't believe she's logged onto the call yet, Your Honor.
All right. Here she is. All right, is it Kasimsri, is that correct?
It's Kasemsi, but no one would know the R silent unless I told you. So you were pretty close.
All right, well, thank you. All right, we're getting awfully close to the 3 o'clock hour, and so is the plaintiff ready to proceed?
Yes, Your Honor, we are.
Is the defense ready to proceed?
Yes, Your Honor.
Does the plaintiff have any pretrial or housekeeping matters that this court needs to address?
Yes, Your Honor. First, may we make introductions for the court?
You may.
Good afternoon, Your Honor. My name is Zoe Appler, and I'm joined today by my second chair, Miss Valerie Letko. And today we represent the plaintiff, Miss Jordan Gilmore.
All right. And Ms. Kasemsi, did you all wish to introduce yourselves?
Yes, Your Honor. I'm sorry to ask this, but apparently my co-counsel needs to be let in.
Ah, there we go. All right.
Okay, perfect. Yes, Your Honor. My name is Jack Kasemsi, and I, along with my co-counsel Jared Koenig, represent the defendant in today's case, Chimes Department Store.
All right. That being said, does the plaintiff have any housekeeping or pretrial motions?
Yes, Your Honor, we do have a few pretrial matters we'd like to attend to. Would you prefer to hear housekeeping or motions first?
Doesn't matter as long as we keep it brief.
No problem, Your Honor. We'd like to draw the court's attention to a pretrial agreement between the parties that witnesses Kelly Danes and Perry Hayden are stipulated as unavailable today, and they may only be called by deposition.
Yes, ma'am.
And Your Honor, to that end, we would like to note that the plaintiff intends to read portions of Kelly Danes' deposition onto the record today. And during that time, with the court's permission, of course, my co-counsel, Ms. Letko, will read the witness's answers from the deposition as I read the questions.
Granted.
Your Honor, we'd also like to note for the sake of time that both parties have made a pretrial agreement to waive objections under Federal Rule 702 regarding the necessary foundation for these two unavailable expert witnesses. So with the court's permission, we'd like to avoid reading the large portions of expert background onto the record during trial today.
That's fine with me.
And Your Honor, just a few questions for you. When laying the foundation to admit an exhibit into evidence, do you want the witness to have the exhibits available to refer to, or would you prefer that we share screen constructively outside the presence of the jury?
It doesn't, again, that doesn't matter to me as long as until it's been admitted, the jury doesn't see the exhibit. Once it's been admitted, you all are free to show it without seeking permission of the court.
Your Honor, for objections, would you like us to ask to be heard outside the presence of the jury, or are we always constructively outside the presence?
No, I'm one of these people, I don't believe in wasting time as far as approaching the bench on stock objections, things like hearsay, things of that nature. You just need to make them. And if it's something that truly needs to be done outside the presence of the jury, then you need to ask to approach.
Understood, Your Honor. And finally, we'd just like to make notice for the court that the parties have stipulated to the admission of several exhibits in today's trial. And I can give Your Honor those numbers if you're ready.
Go ahead.
We've stipulated to the admissions of exhibits 1 through 7.
All right.
Exhibits 10 through 12. And exhibits 16 through 35.
All right. Anything further?
Yes, Your Honor, we do have one substantive motion, but if defense has any other housekeeping matters, they're free to go ahead.
Any housekeeping by the defense?
No, Your Honor, we're ready to proceed.
All right. Substitute motion by the plaintiff.
Yes, Your Honor, we move to pre-admit exhibit 14. Would Your Honor like some further background?
Oh, so I don't have my exhibit list in front of me. Go ahead quickly.
Yes, Your Honor, exhibit 14 is a recorded statement and report that was made by two former employees of Chimes, a manager and an employee. Now, we move to admit these as all statements contained in this report were made by employees of Chime Department Store. Therefore, they're statements by party opponents.
Were they made during the time of their employment?
Yes, Your Honor, and they would also fall under the business record exception of 8036.
All right. Response.
Your Honor, we would object to this pursuant to 403. May it be heard?
Yes, ma'am.
Your Honor, this is a report of an incident that happened 9 years prior to the incident that actually brought us here today. Additionally, this report actually happened under different conditions, and we also don't even know the full circumstances since the employee that wrote the narrative can't be here today, and therefore admitting this would unduly prejudice the defense.
May I respond, Your Honor?
No, I'll take it up when we get there. So just approach the bench and we'll talk about it when we get to the point you want to try to introduce it.
Yes, sir.
Anything else?
Nope, Your Honor. With that, the plaintiff is ready to proceed to opening statements.
Proceed.
Just a moment to set up my well, Your Honor. Can you hear me all right, Your Honor?
I can.
May it please the court. Counsel, members of the jury, carelessness creates consequences. When people are careless, when they go through life with a disregard for safety, they can hurt others. Now think, when a driver gets behind the wheel of a car after having a few drinks, that driver's being careless. They're putting the safety of others in danger by getting behind the wheel. They're choosing to risk hurting others instead of just paying a few bucks for a cab. But members of the jury, you're going to learn that we're not here today because of a careless driver, not even a careless person, in fact. We're here today because of a careless company. Today, you'll learn that the defendant, Chimes Department Store Incorporated, chose to be careless. You'll learn that Chimes chose their image over their employees. You'll hear that this company chose to brush problems under the rug, chose to ignore glaring safety issues, even chose to be lazy. And you'll learn that one of their most dedicated employees, Miss Jordan Gilmore, she suffered the consequences of that carelessness. Good morning. My name is Zoe Appler, and I'm joined today by my co-counsel, Ms. Valerie Letko. And we're here today on behalf of the plaintiff, Ms. Jordan Gilmore. We're here today because Ms. Gilmore suffered an injury while working at Chimes Department Store. And as a result, she's brought this case of negligence against the defendant. You're going to hear today that on January 23rd of 2019, Ms. Gilmore was injured because of the defendant's negligence. We have to prove that to you today by a preponderance of the evidence. Now, to do that, members of the jury, I want to take you back to 2009 here in the great state of Texas, in Waco. That's when Ms. Gilmore proudly began her job as an employee of Chimes Department Store. Today, you're going to meet Ms. Gilmore. She's going to tell you how she dedicated 10 years of her life to working hard as a cashier for the defendant and how she loved her job. She's going to tell you that she always followed the rules, that she gave her best day in and day out. You'll also learn that in 2015, the defendant enacted a new policy, and this policy regarded smoke breaks. Now, we all have our vices, and Ms. Gilmore will tell you that hers was cigarettes, that she was a heavy cigarette smoker and that part of her daily routine at work was taking a smoke break about once a day. Ms. Gilmore will tell you that the defendant's new policy said that all smoke breaks had to be taken behind the store, near the back door. And you'll learn that this policy was put in place to protect the defendant's image, that the defendant didn't want customers to see their employees smoking, so they put their employees out back. A request that might seem reasonable to the average employer. But you'll learn what smoking out back really meant for employees. You're going to see the dangerous conditions that the defendant subjected their employees to. You'll see that any employee who wanted a smoke break, including Ms. Gilmore, had to stand on this exposed concrete platform behind the store, right next to the dumpster. A dilapidated platform, a platform with no handrail, without adequate lighting nearby, a platform with chunks missing from it. You'll learn that this was the designated smoke area the defendants chose for their employees. You'll learn that the defendant knew that this smoking area violated multiple building codes, multiple government regulations, and that they never inspected it for safety concerns. You're going to learn that the defendant was careless. And you'll learn exactly what that carelessness meant for employees like Ms. Gilmore. You're going to hear about the day that Ms. Gilmore was injured, January 23rd of 2019. It's a cold, windy night here in Waco. By 7 p.m. this time of year, the sun is gone, the darkness has set in. And around that time, Miss Gilmore and her coworker go outside to take a smoke break. They step out back, just as they're required to do. They open the back door and are met with a rush of cold air, a gust of wind. Miss Gilmore sends those stairs to the ground, choosing to withstand the cold instead of smoking in the doorway so that the smell from her cigarette wouldn't leak inside the store. But the stairs and platform she navigated so easily during the day, you're going to learn, are much tougher to take in the darkness because there's no lighting. There's no street lamps, exterior lights illuminating that staircase. Only a sliver of light comes through from the opening in the door beside the storage room. Now, Miss Gilmore quickly smokes her cigarette and she heads back inside. But as she climbs those stairs on that platform, with so little light, no railing to grab onto, she slips. No guardrail to catch her. She falls to the ground, landing on her right leg, damaging her right knee. Members of the jury, Ms. Gilmore will tell you that after that fall, she had to have her entire right knee replaced. All because the defendant chose not to prioritize the safety of their employees. But you're not just going to hear from Ms. Gilmore today. You're also going to hear testimony from an expert witness, Kelly Danes, a mechanical engineer. Now, unfortunately, Ms. Danes is unable to be at trial today, and she's been designated by this court as an unavailable witness. But don't worry, all that means is that instead of Ms. Danes coming on screen here today and testifying live, you're going to hear portions of her testimony from a previous deposition. And I'm going to read it to you along with my co-counsel, Ms. Letko. You'll hear that within Ms. Danes' testimony, she's going to make it clear that Chime's department store violated numerous federal guidelines, particularly those that govern handrails, that govern lighting, and that govern staircases. And the evidence will show you that this area, that dock, wasn't safe, and that the defendant knew it wasn't safe, that they knew this platform was dangerous, that they knew their stairs weren't safe, knew that their lighting was inadequate. And the evidence will show that they didn't do anything to fix it. And you'll learn that they couldn't be bothered to make this area safe, this area that was used not only by smokers, but even by other employees that were instructed to take out the garbage, employees that were loading and unloading shipments. You'll hear today that the defendant put all of their employees at risk. Evidence will show you that the defendant chose carelessness, chose laziness, chose ignorance over their employees, over safety. And that Miss Gilmore, she suffered the consequences of that carelessness. That's why at the end of today's trial, I'm going to come before you again, and I'm going to ask you to look at the facts, to look at the evidence, and to apply the law, and to find the only verdict that's supported by the truth. I'll ask you to find the defendant liable. Thank you.
Defense opening.
Yes, Your Honor. May I proceed?
You may proceed.
May it please the court. Members of the jury, we're here today because the plaintiff just keeps trying to slip on by. You see, the reason why we are in court today is because the plaintiff made a choice to try to slip on by a door that was completely blocking their path, and that could have been opened all the way or closed all the way. But because the plaintiff decided to slip on by that door, they injured themselves. And now the plaintiff is trying to slip on by taking responsibility for their choices that have brought us here today. And if we let them do that, a local Waco family business is going to suffer. I want to tell you a little bit about who my client is, Chimes Department Store. If you're from Waco, you know that it's a local family store here, a store that was opened by Reese Geller, who is the current owner, and you're going to hear from today, but we'll get to him. The store was opened by Reese Geller's grandpa decades ago. His grandpa wanted to make sure that Waco had its own local department store so they could focus on family and the community. Chimes Department Store took off. It did so well that the grandfather was able to pass it down to Reese Geller's dad. Reese Geller's dad continued the legacy on, and that's when Chimes Department Store moved to their current location on Bosque Avenue. When Miss Geller was growing up, watching Chimes Department Store take off, watching her family put in countless hours to this department store, she decided that's what she wanted to do. When it's time for her to choose where to go to college, she chose to go to Baylor so that she could be close to the family business. When she had the option of getting an MBA, she decided not to do it because her priority was starting her work for her family legacy. So when Miss Geller graduated from college, she started out as a buyer at Chimes Department Store because she didn't want to just walk in and have it handed to her. No, Miss Geller wanted to start from the bottom up. She wanted to earn her place in her family's legacy. And thankfully, she was able to achieve that. And she's currently the owner. I've told you a lot about Chimes Department Store and its long history here in Waco. And you just have to know that right now that could all be ruined. And I want to talk about how this case has brought us here and how it could affect Chimes Department Store. So you just heard a long story from the plaintiff about the night that the plaintiff injured herself. I want to pull something back up for you just so you can really look at what we're talking about here. Mr. Koenig, could you please pull up that picture? Members of the jury, when the plaintiff told you that story about the fall, they weren't talking about some 10-foot platform off the ground. They weren't talking about a balcony. They weren't talking about something with flights of stairs. No, members of the jury, they were talking about a back entrance to a department store that was about a couple feet off the ground with 5 steps. So when the plaintiff is presenting their case today, I really want you to think about and picture where this event actually took place. Thank you, Mr. Koenig. Now, when the plaintiff takes a stand today, Ms. Gilmore, I want you to focus on 2 things, members of the jury. One, I want you to focus on how familiar the plaintiff was with this back entrance, with this loading dock. Because as you'll hear today, members of the jury, that the plaintiff has gone out those doors, down those steps, back up them, and back through those doors thousands and thousands and thousands of times with no incident, with no trouble. The second thing that I want you to really pay attention to when the plaintiff is on the stand is what were her choices the night of the accident? Because what you're going to hear, members of the jury, is that the plaintiff went out on that loading dock like they had hundreds of thousands of times before. They went down those stairs and then they went back up those stairs just like they had hundreds of thousands of times before. But this, members of the jury, is the part that's important. The plaintiff talked about careless choices, but I want to talk about the careless choice that brought us here today. When the plaintiff was walking up those steps, their friend was holding the door half open, and that half open door completely blocked the plaintiff's path onto the platform. Members of the jury, that door can be opened all the way to the wall. That door can be closed all the way. But no, the plaintiff didn't choose to simply ask their friend to do either one of those. The plaintiff didn't even choose to just grab the door and push it to the wall themselves. The plaintiff decided to slip on by this tiny sliver on the loading dock. The loading dock that they had walked on hundreds of thousands of times before and knew didn't have any railing, because loading docks don't have railing on them. And that, members of the jury, that's the careless choice that brought us here today. We're not saying that the plaintiff's injury isn't sad. It's tragic that the plaintiff was injured, but it's important to know how they were injured and whose choices led us to that. And it was their own. After the plaintiff presents their case, we're going to let you get to know Reese Geller. We're going to call her to the stand. We're going to go into detail about her family business so she can tell you about how proud she is. And then we're going to show you something. We're going to show you a lease. This lease is between the defendant, Chimes Department Store, my client, and their landlord, Kermit. On this lease, you'll see that back area, including that loading dock, was not an area Chimes Department Store leased. No, that back area was known as something called a common area. And as you're going to see on the lease today, members of the jury, the sole responsibility for the upkeep of that common area was on the landlord. You're also going to hear some information from Perry Mason's deposition, who can't be here today. But just remember that Perry Mason is the only OSHA inspector who you're going to hear information from today. And when Perry Mason looked at that dock, looked at that loading dock, he saw that it met all the standards. The plaintiff has the burden of proof today, but we do too. And that's because we believe that at the end of today's trial, you'll see that it was the plaintiff's choices and the landlord's control that brought us here today. And because of that, at the end of today's trial, we're going to ask that you find Chimes Department Store not liable.
First witness, plaintiff.
Yes, Your Honor. The plaintiff calls Ms. Jordan Gilmore to the stand.
You all can presume that all witnesses have been pre-sworn.
Understood, Your Honor. May I proceed?
You may.
Good afternoon. Please introduce yourself to the members of the jury.
Hi, my name is Jordan Gilmore.
How old are you, Ms. Gilmore?
Just turned 49.
And where are you from?
I'm from Waco, Texas.
Do you still live in Waco?
Yes, ma'am, I do.
Do you work here?
Well, I did. I worked at Chimes Department Store for about 10 years, but since the accident, I've been unemployed.
What is Chimes Department Store?
Oh, it's a local department store, kind of like a Macy's here in Waco. Sells all sorts of different things.
What was your position with Chimes?
I was a clerk at the front of the store, so I helped check people out.
You mentioned an accident. What was that accident?
So on January 23rd, 2019, I fell from a loading dock on the back of the store and was pretty severely injured from that.
What was your injury?
I had to get a total knee replacement ultimately.
Objection, Your Honor.
Yes, ma'am.
This case is bifurcated today, and damages is not part of this. So going into the extent of the injury is not permissible.
All right. The court will allow the defendant to go so far as to explain what the end result was, but I don't want her going into anything further than just this issue about the knee replacement. Further than that, she's met her prima facie burden of proving she was injured.
Yes, Your Honor.
Ms. Gilmore, what was your injury?
My knee and hip was injured, and I ultimately had a total knee replacement on my right knee.
Now, I want to talk to you about the day of that injury. What day was that?
It was January 23rd, 2019.
And do you recall that day?
Yes, ma'am, I do. It was pretty cold.
Were you working that day?
Yes, I was.
What shift were you working?
The closing shift, so it would have been noon to 8 p.m.
During that shift, did you take any breaks?
Yes, I took my normal lunch break, and then I took a smoke break later that evening.
Around what time?
7 p.m.
And where did you take this smoke break?
It was behind the store, kind of in the loading dock area back by the dumpster.
Why did you take your smoke break there?
That's where we were required to take our smoke breaks.
Now, you said you were required. When did you find out you were required to do this?
I believe it was 2015. Around then, we got a memo from management specifying where we needed to take our smoke breaks.
Directing opposing counsel and the witnesses' attention to what's already in evidence as Plaintiff's Exhibit 1. Permission to publish, Your Honor?
If it's already in evidence, you can publish anything you'd like.
Can you see that okay, Ms. Gilmore?
Yes, ma'am, I can.
And can you tell us what we're looking at here?
Yes, this is the memorandum I just discussed from management to all employees, telling us where we could take a smoke break if we wanted to take one.
And what was the date of this memo?
It says July 1st, 2015.
Can you tell us what this memo says about your smoke breaks?
Yes, so it says, as you've been told before, if you're going to smoke, you need to smoke out behind the store where the dumpster is. That is the only place you should take smoke breaks on the premises.
Retrieving the exhibit. Ms. Gilmore, did you ever take a smoke break out in front of the store?
No, ma'am, not that I can recall.
Was this the first time you had ever taken a smoke break out back?
No, I'd taken many smoke breaks before that night.
Can you describe for the members of the jury the area where you're supposed to take those breaks?
Sure. So it's behind the store. As I mentioned, there's a loading dock, and then you take some stairs down the loading dock, and there's a dumpster. That's usually where I go to make sure that no smoke, blows back in the store. I don't want to get in trouble for that.
Publishing what's already in evidence as Exhibit 2, or excuse me, Exhibit 19. My apologies, Your Honor. Can you tell us what we're looking at, Ms. Gilmore?
Yes, this is a photograph of the back part of the store where I usually take my smoke breaks and where I fell.
All right, retrieving the exhibit. Now, I want to walk through step by step what happened when you went out to smoke on January 23rd. First off, did anyone accompany you?
Yes, my coworker Riley Huntsberger did come with me.
And when the two of you got outside, what was the weather like?
Oh, it was freezing, especially for Waco. It was dark at that time of year, pitch black.
Was it raining?
Not that I recall, but it was fairly windy.
Were there any lights on when you got outside?
No, ma'am, no lights outside.
Well, are there any lights in that general vicinity?
Yes, there is a light, but it was not on the night that I fell.
Where is that light?
The light is on the back side of the building, but we don't actually have access to it in Chimes.
Publishing what's already in evidence as Exhibit 22, or Exhibit 2, excuse me. Now, Ms. Gilmore, is the light that you're referring to the one circled in red here?
Yes, that's correct. I actually circled that.
Now, have you ever seen this light on before during one of your smoke breaks?
No, I don't believe that I have.
Are you able to turn it on or off?
No, we don't have access to the light switch in the Chimes store.
Do you know where the light switch is?
I believe that it's in the store next to Chimes, a Tractor Supply store.
Did you ever complain about this lack of a light switch to your management?
Yes, we did complain about the light once.
How did your management respond?
I believe that they said something along the lines of, we just don't have access to the switch, so there's nothing we can do about it.
Retrieving the exhibit. So Ms. Gilmore, you go out into the cold, dark night. Is there any light coming from anywhere at all?
The only light that we had was the light that was coming from the inside of the store.
And how was that light getting outside?
My friend Riley was holding the door open. Like I mentioned, it was pretty windy. So trying to steady the door and give me a little bit of light so I could generally see the area.
Did you stay in the doorway with your coworker?
No, I did not.
Why not?
I'm kind of a rule follower and didn't want the smoke to blow back into the building. So I walked down the stairs back kind of behind near the dumpster area to make sure that the smoke wouldn't blow back into the store.
Could you see where you were stepping?
I could see generally where I was stepping, but it was pretty dark.
Now, was there a railing for you to hold on to help you get down?
No, there was no railing.
Have you ever seen a railing back there?
I haven't, no.
So did you make it to the bottom of those stairs okay?
Yes, I did. Since there's no railing, I kind of use the wall that's right there to make sure that I make it down okay.
What happened when you got to the bottom?
When I got to the bottom, it was pretty freezing outside. So I tried to just, take my smoke break quickly and then walk back up.
And what did you do when you finished your cigarette?
Well, after I finished my cigarette, I, got rid of it and then started to walk back up the stairs, steadying myself on the wall as I went.
Did you make it inside safely?
I wouldn't say safely, no.
What do you mean?
Well, the landing at the top of the stairs, where Riley was kind of holding the door open. It was windy, so when I got to the top, there wasn't very much space for me to move around, and I felt myself start to slip, but there wasn't anything I or Riley could do at that point. I ended up falling and landing on my butt.
Okay, I want to walk through that fall step by step. Now, where were you standing in the moments before you fell?
I was trying to, get to moving up the stairs and onto the landing when there wasn't very much room because of the door.
I'm publishing what's already in evidence as Exhibit 4. Can you tell us what we're looking at here, Ms. Gilmore?
Yes, this is a picture of what the door looked like the night that I was trying to get up the steps.
Now, you said that you had to step to go around this door. Where did you step on this picture?
That kind of tiny area, hard to describe in the picture, but just to the left of the door, those, few inches right there next to that hole kind of.
How much room would you say that you had on that landing to go around?
Hard to tell, probably less than a foot.
All right, retrieving the exhibit. So you said that you slipped and fell. Where did you end up after you had fallen?
I ended up on the ground, kind of below the loading dock, next to the stairs on the ground.
Did you land on your feet?
I believe I did initially, but I know I ended up on my butt. I landed on my right side pretty hard.
Now, what happened to you after you fell?
Well, Riley was right there, thankfully, and came down to check on me. And at this point, I needed help to get up the stairs. So I knew that something was wrong.
Did Riley help you get upstairs?
Yes, thankfully.
Now, how are you feeling at this point?
At this point, there's still some numbness and I, have a scar.
Apologies, Ms. Gilmore. At that point in the evening on January 23rd.
Yes, ma'am. At that point in the evening, I did finish my shift, but, I went home, took some Tylenol, but the next day it was pretty bad.
Now, did you ever speak to any management at Chimes about this injury?
Yes, I did right away. That night, spoke with Lane Kim.
Who is Lane Kim?
A manager at the store.
What did she say to you about this injury?
Well, she said, yeah, we probably should have fixed those steps a long time ago.
Miss Gilmore, to your knowledge, do you know if Lane Kim told the owner of Chimes about this?
I believe that she mentioned she had, yes.
So to be clear, your manager told you Chimes knew how dangerous this smoke area was, but they still designated it as the smoke area.
Yes, that's where we were supposed to smoke.
Thank you for your time, Miss Gilmore. I pass the witness, Your Honor.
Cross.
Yes, Your Honor.
Proceed.
Miss Gilmore, like we just talked about, you're a smoker, right?
Yes, ma'am. I was, not anymore.
But during your 10 years at the Chimes department store, you were a smoker.
Yes.
You smoked a pack a day.
On average, yes.
That's about 26 a day, right?
I believe so.
And you talked about this smoke break policy earlier, right?
Yes, ma'am, the memorandum.
And in your words, that policy made sense to you, didn't it?
Yes, I suppose it did.
You suppose it did, or did it make sense to you?
No, ma'am, yes, it did. It made sense.
Now, during your 10 years at Chimes, you would take a smoke break every day, right?
Yes, I would say so.
You take out the trash once or twice a day.
Yes.
And you estimated that you would go out those doors, down those stairs about 20 times a week.
Yes, that's correct.
So if you worked there for 10 years, that means you took that trip thousands and thousands and thousands of times, right?
If I think through the math, maybe 10,000 times, around there somewhere.
Yeah, we'll go with 10,000 times. And out of those 10,000 times before January 23rd, 2019, you never fell down those stairs, did you?
No, not before the 23rd.
You never fell off that loading dock?
No, ma'am.
You never had any issue taking out the trash or taking your smoke breaks?
No, ma'am, not until that day.
Let's move on to that day in question. Your shift on January 23rd, 2019 was from 12 to 8 p.m.
That's correct.
And according to you, the sun was up probably for the first 6 hours of your shift.
Yes, I know that it was dark by the time I fell around 7.
That's right. You chose to take your smoke break at 7, right?
Yes, that's when I was able to go that day.
But that's what time you chose to go at.
Yes, that's when I was able to go out.
And whenever you went out there, you knew that the lights weren't going to work, right? Because you knew that Chimes didn't control it.
Yes, I did.
Because you were told that Chimes couldn't control that switch.
Yes, I was.
Now, on that night, you walked out the doors.
Yes.
But you chose to walk down the steps, didn't you?
Yes, I did. As I'd mentioned, I didn't want the smoke to blow back into the store. I didn't want to get in trouble.
Now, when you walked down those steps, you didn't fall.
No, ma'am.
You took your smoke break.
Yes.
And then you walked back up the steps, right?
Yes, I walked back up and down, kind of steadying myself on the wall.
Now, your friend Riley decided to stay at the top of the loading dock, right?
Yes.
And so when you had made it to the top, Riley was holding open the door.
Yes.
And that door was blocking your path onto the platform, wasn't it?
Yes, it was.
Now, I want to clarify something, Miss Gilmore. That door can be opened all the way to where it's against the wall, right?
Yes, that's true.
And you can also close that door, can't you?
Yes, of course, but then it would have been pitch black. Our only light was coming from inside the store.
So when you got to the top of the steps, you didn't grab that door to open it, did you?
No, Riley was holding on to it because it was pretty windy.
But you did not decide to open that door more, did you?
No, I didn't.
You didn't ask Riley to close the door so you could get up?
No.
I want to show you what's been previously admitted into evidence as Exhibit 3. Mr. Koenig, could you pull that up? Ms. Gilmore, we looked at an exhibit that was almost identical to this earlier. So that is the position the door was in when you got to the top of the steps, right?
Yes, ma'am.
And you saw this much space in between the door and the platform, right?
Yes.
And you chose to try to go around it.
I mean, as I'd mentioned earlier, it was really cold that night and I was just trying to get in the store as quickly as possible.
I understand, Ms. Gilmore, but I'm just trying to clarify that you chose to go around the door with that much space.
I mean, you know, I could generally see the area, but as I'd mentioned, it was just trying to get inside and get out of the wind.
Ms. Gilmore, I'm not asking what you could see around the area. All I'm asking is that you chose to go around the door with that much space.
Yes, I did.
Now, like we mentioned before, that door can be opened all the way, can it?
Yes.
Mr. Koenig, could you please turn to what's already been pre-admitted into evidence? Now, that is how wide those steps are, aren't they?
Yes, I would say so. That's an accurate picture.
But you still chose to go up with that small of a space.
Yes, the way the door was positioned, that's how I went up that night.
Now, I want to clarify something. When you fell off the platform, you decided to jump back, didn't you?
Yes, I figured if I could try to land on my feet, maybe it would be better, but didn't work out for me, clearly.
And when you went back into the store that same night, Riley had pushed that door all the way against the wall, right?
Yes, I believe so when Riley was helping me up.
Mr. Koenig, you can take that down. So when you went back up those stairs right after your fall, your path was wide open.
Yes.
No further questions, Your Honor.
Redirect.
No redirect, Your Honor. May Ms. Gilmore be excused?
May. Next witness.
Your Honor, at this time, with the court's permission, the plaintiff seeks to admit portions of unavailable witness Kelly Dane's prior deposition testimony taken on July 1st of 2020 by having my second chair, Ms. Lecco, come read her answers while I ask the questions.
You may proceed.
Directing the court's attention to page 2 of the deposition, page 80 of the record, line 6. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Kelly Danes.
Directing the court's attention to page 8 of the deposition, page 86 of the record, line 16. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question, and the facilities in question must be in compliance with those codes and regulations.
What is the basis for that opinion?
Well, in regards to the International Building Code, the city of Waco adopted that code and incorporated it into its own city ordinances on March 20th of 2001. The OSHA regulations were enacted into law in 1970. So both the IBC and the OSHA regulations would apply to whoever was responsible for the maintenance and repair of the area where this incident occurred.
Do you know or have any opinion on who was responsible for the maintenance and repair of these steps behind the Chime store?
No, that's not what I was asked to do. I assume it was Chimes, but that's just a guess. My job was to look at the steps themselves and see if they met the code.
All right, so what portions of the IBC codes and the OSHA regulations did you find important in this case?
First, the general duty clause in the OSHA regulations, which can be found in 29 USCS section 654, and the maintenance provision under section 3401.2 of the IBC.
Why are those significant in this case?
These are general provisions that require an employer and or the party that is responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained maintained condition, free from recognized hazards. Here, as you can see from the photographs that I took during my inspection of the stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of a light switch to turn on the light above those stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant didn't have such a program and never identified or corrected these hazards. So fairly clearly, the defendant violated these requirements under both the IBC and the OSHA regulations.
Directing the court's attention to page 11 of the deposition, page 89 of the record, line 6. What other portions of the IBC codes and the OSHA regulations did you find important in this case?
OSHA 1910.37B1 and IBC 1006.1, which both deal with lighting.
Why are those significant?
Well, 1910.37B requires that lighting must be adequate and appropriate for a building exit like this one. And 1006.1 requires that any means of egress must be illuminated at all times the building is being occupied. In this case, there was a light above those stairs, but there was no switch for that light inside the Chime store. So there was no way for the employees to turn that light on when they went outside at night. A switch like that should have been installed long before this incident to make sure that employees could see where they were stepping.
Directing the court's attention to page 11 of the deposition, page 89 of the record, line 24. What's next?
Next, we move to OSHA 1910.23D1 and 1910.24H and IBC 1009.11.
Why are those significant?
All of these provisions require that stairways or flights of stairs must have guardrails or railings on any exposed side. Here, there was no guardrail on these stairs on the exposed side, which is obviously dangerous.
Do you know if there was ever a guardrail on those stairs?
Yes, there was, and it was removed at some point.
Directing the court's attention to page 14 of the deposition, page 93 of the record, beginning at line 22. Anything else?
IBC 1005.2 states that doors opening into the path of egress travel shall not reduce the required width to less than 1/2 during the course of the swing, and that when fully open, the door should not project more than 7 inches into the required width. When the door is open like it was at the time of this accident, it obstructs the path up or down the stairs to a 1-foot space between the edge of the door and the edge of the platform or the stairs where the plaintiff fell.
Any final thoughts?
Honestly, I just don't know what the defendant was doing here. All of this could have easily been fixed by putting up a guardrail around those stairs and landing and patching the cracked concrete on those steps. It would have been easy. And if the defendant had taken these simple steps, putting a guardrail along those stairs, putting a guardrail around that landing, making sure it was well lit, patching the concrete, then the plaintiff's fall would not have happened.
Thank you. Your Honor, at this point, we pass the witness.
All right. Any cross by the defense of this witness at this time?
Yes, Your Honor. Turning to page 4, line 1, or excuse me, I'm on the wrong deposition, Your Honor. Sorry, Your Honor. All right, turning to page 4, line 14. Over the course of your career, how many incidents have you investigated?
Over 60.
Turning to page 10, Your Honor. Actually, Your Honor, at this time, we're done reading from this deposition.
You pass witness.
Yes, Your Honor.
Next witness by the plaintiff.
Your Honor, at this time, the plaintiff rests.
All right, and we'll take about maybe a 3-minute recess to let the defense get ready. And
Your Honor, just
yes.
for the record, the defendant would like to make a Rule 50 motion for judgment as a matter of law. Maybe the plaintiff has not provided any sufficient evidence to meet their burden of showing proximate cause between the defendant's actions and the fall that the plaintiff sustained. All they've shown is that it was the plaintiff's choices that led to that fall and was the proximate cause.
Response.
Yes, Your Honor, we have shown that this injury was proximately caused by the defendant's negligence. Now, we've heard from the plaintiff herself that she had complained to management about the fact that there was no light in the back. She had explained to the members of the jury how unsafe those stairs were and how the only reason that she fell was because she could not see due to the fact that the defendant breached their duty to provide that light, to provide safe conditions for their employees. And furthermore, we've heard testimony from an expert witness today specifying how each of those federal codes were violated by the defendant breaching their duty. Therefore, we have provided enough evidence to meet our prima facie case at this point, and the motion should be denied.
Motion's denied. We'll take our break and then we'll start back in just a moment.
What time would you like us to be back, Your Honor?
We'll give it about 3 minutes. That'll be plenty.
Understood.
All right, counsel, I apologize. I ran over time. We're burning daylight. So plaintiff, you may, or excuse me, defense, you may proceed with your first witness.
Thank you, Your Honor. The defense calls Reese Geller to the stand.
All right.
Good afternoon, Ms. Geller.
Good afternoon.
Please introduce yourself to the jury.
My name is Reese Geller.
Ms. Geller, where do you live?
I live here in Waco.
Do you have any family in Waco?
Oh, yes. I have my husband and my 3 children and my parents and grandparents. We're all from Waco.
Do you work in Waco?
Yes, I do work in Waco.
What's your job?
I am the owner of Chimes department store here in Waco.
Tell us a little bit about Chimes department store.
Okay, so yeah, Chimes is just like local department store. It's kind of like a J.C. Penney's or Macy's, and we just sell all kinds of stuff like clothes and shoes and tools and just miscellaneous things.
Ms. Geller, how did you get involved at Chimes department store?
Oh, so Chimes is a family business that my grandparents opened decades ago, and then my parents owned it after them, and then now I'm the owner.
When did you start working at Chimes?
I started working after I graduated from college, so basically my entire career.
And where did you start? What level did you start working at Chimes?
I started at the very bottom. I was like in the buying department, so yeah, and I just worked my way up to the top, and now I'm the owner.
Ms. Geller, I want to talk about the incident that brought us here today. Do you know why you're here?
Yes, I do.
What do you know about the incident?
An employee fell on the back at the back of the store and injured herself.
Do you know where that employee fell?
Yes, on the stairs at the back of the store by the loading dock.
Did she fall off the stairs or did she fall off the loading dock?
Off the loading dock, sorry.
That's all right. Now, I want to talk about this loading dock. Does Chimes department store own this loading dock?
No, we do not. No.
Does Chimes department store lease this loading dock?
No.
Now, how do you know this, Ms. Geller?
It's in our lease, clearly stated, and it's not a part of our lease, so.
I'm going to pull up that lease now, which has been pre-admitted, part of that lease. Mr. Koenig, could you pull up Exhibit 12? Now, this is a picture from your lease. Ms. Geller, could you tell us what we're looking at?
Yes, this is the Chimes department store, and the lines show the leased portions that Chimes leases out.
And what about that red X? What does that show?
That's the loading dock.
And is that loading dock in the leased area?
No, it is not.
If the loading dock isn't in the leased area, what area is that referred to as?
That's the common area.
Ms. Geller, I'd like to move your attention to page 9 of this lease we've been talking about. We're going to look at section 6.1. Mr. Koenig, can we get a little closer of that? There we go. Ms. Geller, can you see that?
Yes, I can.
Could you read to us what 6.1 says? The highlighted parts are fine.
The term common area is defined for all purposes of this lease as the part of the shopping center intended for the common use of all tenants, including, among other facilities, as such may be applicable to the shopping center, parking areas, private streets and alleys, landscaping, curbs, loading areas, sidewalks, malls, promenades, enclosed or otherwise, lighting facilities, drinking.
Thank you, Ms. Geller. Now, I want to bring your attention to section 6.3, which can be found on page 10 of this lease. So we're going to look at this little section right there. Now, Ms. Geller, could you read this to us?
Yes. Landlord shall be responsible for the good and safe operation, management, and maintenance of the common area, and landlord shall operate, manage, and maintain the common area in good, attractive, and safe condition during the lease term.
So, in simple terms, what do you understand this to say?
That it is the landlord's responsibility to upkeep the common areas.
And is that loading dock a common area?
Yes, it is.
Thank you, Mr. Koenig. You can take that down. So, Ms. Geller, this loading dock, did there used to be railing around it?
Yes.
Who removed that railing?
The realty or the Kermit Realty Group, which is the landlord.
Did you guys want this railing to be removed?
Yes, we did. You can't have a loading dock with railing.
Could you remove the rails yourself?
No, we could not because it's not part of our lease. We don't have control over the common area. So we were not able to take the railing off ourselves.
Now, this loading dock, how often do you receive deliveries on this loading dock?
Every day, just about.
And how has removing the railing helped your employees with their unloading duties?
Oh, it helps tremendously. I mean, if there was no loading dock, I mean, they would not be able to take the products, into the back of the store easy at all. So.
No further questions, Your Honor. I pass the witness.
Cross.
Yes, Your Honor. Good afternoon, Ms. Geller. Can you hear me okay?
Yes, I can.
Ms. Geller, you've been at Chimes for over 20 years, right?
Yes, that's correct.
Last 10 of those, you've been the owner?
Yes.
And fair to say that as the owner, you want your customers to be safe in your store, right?
Absolutely.
Same goes for your employees, right?
Yes.
But you don't inspect the inside of your store for potential safety issues yourself, do you?
The inside of the store?
You don't inspect the inside or outside of the store for safety issues yourself.
Well, we advise our employees, to use good safety practice, and if they see any, unsafe conditions, to let us know. But we're not a safety company, so no, I don't go around usually doing safety inspections of the store.
So directing you back to my question, neither you nor anyone in your management team inspects your store for safety issues?
Not specifically, no.
And you claim that you wouldn't even know what to look for, right?
I would know what obviously is unsafe, I would think. So I wouldn't, it's common.
But in your words, Ms. Geller, you wouldn't even know what to look for, would you?
No.
Now, you referred to the platform behind this store as the loading dock, right?
Yes.
All right, I want to talk to you about that loading dock. Now, you'd say that deliveries are dropped off there, right?
Correct.
They come almost every day.
Correct.
So you try to keep that area clean.
Yes, correct.
And to your knowledge, nobody besides Chimes uses this particular area?
No, I don't know anybody that uses it, but they're more than welcome to use it.
Nobody besides Chimes cleans this area, correct?
Not that I'm aware of.
Now, besides being used for deliveries, this is also where you keep Chimes' dumpster, correct?
Correct.
You yourself ordered that dumpster?
Yes.
You determined that it would be located out back, right?
Yes.
Not your landlord?
Correct.
And to clarify, that's Kermit Realty?
Correct.
You didn't request permission from Kermit Realty to bring this dumpster in, right?
No.
Now, your store employees throw away your business's trash into that dumpster, right?
Yes.
Which requires them to go out those back doors?
Yes.
And head down the stairs to get to the dumpster?
Yes.
Okay. Now, I want to talk to you a little bit about what you and Chimes knew before Miss Gilmore's accident. Now, your company maintains employee records, right?
Yes.
These records include workplace injury reports?
Yes,
And your company labels these documents as recorded statement guides, correct?
yes,
As the owner of Chimes, you have access to those records?
correct.
You'd recognize one of those records if I showed it to you here in court today?
Yes,
Directing opposing counsel and the witness's attention to what has been pre-marked as Plaintiff's Exhibit 14. Your Honor, permission to share this with the witness constructively outside the presence?
Outside the presence.
Can you see that okay, Ms. Geller?
yes, I can.
You recognize this, don't you?
Yes, I do.
This is a recorded statement guide.
Yes,
And this report details an accident that occurred on January 12th of 2010.
that's correct.
And this record was kept in the course of regular business, right?
Yes,
It was made by the store manager at the time?
yes,
And it was made about 4 days after the incident occurred, correct?
yes,
This is a fair and accurate copy of that record?
yes,
Your Honor, at this time, plaintiff offers Exhibit 14.
Response.
Your Honor, we renew our objection pursuant to Rule 403. As we stated before, this report talks about an incident that happened 9 years before the incident we're here today for. Additionally, Your Honor, the employee who writes a long narrative in this isn't here today for us to question about the specific circumstances of what happened to them, and therefore allowing this into evidence would unfairly prejudice the defense.
May I respond, Your Honor?
You may.
We do not intend to use this document for that purpose. We intend to use this document to show notice, that the defendant had noticed that there were problems with these stairs and didn't fix them afterwards.
All right. I think I can fix it with a limiting instruction. So the objection is overruled, but I will give a brief limiting instruction to the jury that they can use it to determine whether or not they feel like the defendant was on notice, but that's strictly up to them.
Yes,
It's
Your Honor.
conclusions they draw from the exhibit. Jurors, you're so instructed.
Permission to publish to the screens of the jurors, Your Honor?
You may.
Now, Ms. Geller, this is an injury report regarding a prior Chimes employee, correct?
yes,
And this report indicates that the incident occurred on January 8th of 2010.
yes,
All right, now directing your attention to the bottom of the page, the section entitled Accident Loss. Can you see that okay?
yes,
Now, if you read silently as I read aloud, this says, I was out back on the loading dock. My supervisor, April Nardini, asked me to take out some trash and throw it in the dumpster behind the building. It was dark outside when I opened the door and the light wasn't on. So I went back in and asked April where the light switch was. She told me there was no switch for that light in our store and that the only switch for that light was in the store next door, so there was nothing she could do about it. She told me to just leave the door open and use the light from inside the building so I could see where I was stepping. I did exactly that, but as I was walking down the steps, I slipped on what I think was loose concrete and I fell face first onto the ground at the bottom of the steps. There was nothing for me to grab onto, so I couldn't stop my fall. Did I read that correctly?
yes,
Now, moving on to the final page of this document, the last item. And this form asks, are there any steps that should be taken by Chimes to help prevent such injuries in the future, right?
yes,
And the supervisor who completed this form wrote, make sure there is adequate lighting on the loading dock. Did I read that correctly?
yes,
Retrieving the exhibit. So let's talk about what you did in the 9 years between this accident and Miss Gilmore's accident. Now, after this accident in 2010, you didn't install a new outdoor light by the steps, did you?
no,
You didn't contact your landlord about getting a working light switch for that light?
no,
You didn't even put a flashlight by the door for your employees to use at night?
no,
Didn't send out a memo warning employees not to go down those steps?
no. That was the way to go down the steps to get down.
You didn't put any white tape on those steps to reflect back?
No,
Didn't even post a warning sign?
no.
And you didn't install a hand railing, right?
We couldn't install a hand railing. It wasn't a part of our lease, so we weren't able to add any fixtures onto the property.
All right, well, let's talk about that then. You claim that it wasn't your duty to make this back exit area safe, right?
Correct.
Most notably, the light that you didn't have a switch to control.
Correct.
You say it wasn't your problem, right?
Sure.
But Miss Geller, you'd agree with me. You could have told your landlord about that lighting problem.
I could have, I suppose.
You could have told your landlord about the concrete on those steps.
I thought the steps were safe enough for a loading dock, so I didn't see a problem with them at that time.
So that's a yes. You could have told your landlord that there were chunks of concrete missing from those steps.
I could have, yes.
You could have told your landlord to put a guardrail on the stair portion of that loading dock, correct?
Possibly.
But you didn't do those things.
No.
You never asked your landlord to repair any portion of that loading dock, right?
Correct.
And your lease did allow you to make alterations to the inside of your store, didn't it?
Yes.
And in fact, after Miss Gilmore's accident in 2019, well, you finally installed a light switch inside your store.
Objection, Your Honor. Pursuant to Rule 407, this is a subsequent remedial measure.
May I respond, Your Honor?
Quickly.
Your Honor, there is an exception to 407 today, as defense counsel is contesting ownership as well as feasibility today of whether or not a switch could be installed to control that light. Therefore, this is admissible under 407.
All right, well, the court will overrule the objection, but instruct the jury it is only for the purposes of them to determine control of the premises and nothing more. Proceed.
Ms. Geller, after Ms. Gilmore's accident in 2019, you finally installed a switch inside your store that could control that outdoor light, right?
Yes.
Someone at Chimes did that, didn't they?
Yes.
Your landlord didn't do that.
Correct.
Thank you. I have nothing further.
Redirect.
Yes, redirect, Your Honor.
Proceed.
Now, Ms. Geller, I want to clarify one thing. When you installed that light switch, did you install it on that loading dock?
No.
Where'd you install that light switch?
We installed the switch inside our building, which we lease.
And also, Ms. Geller, I want to look back at that incident report that was shown. Now, Ms. Geller, can you see that incident report?
Yes.
Tell the jury how many incidents like this happened between 2010 and 2019.
0.
Additionally, Ms. Geller, could you tell the jury where this incident report says that the employee fell?
Can you highlight the portion that you are referring to? I'm sorry.
That's fine. Oh, right here. Can you see me highlighting it?
Yes. Down the steps.
And just to clarify, where did the plaintiff who's brought us here today fall?
On the loading dock.
No further questions, Your Honor.
Any recross?
Not based on that, Your Honor.
Next witness.
Your Honor, at this time, the defense will be reading some lines from Perry Hayden's deposition.
Proceed.
Directing the court's attention to page 2 of Perry Hayden's deposition, and we'll be starting on line 11. What do you do for a living?
I'm a compliance, safety, and health officer with the Occupational Safety and Health Administration.
Moving on to page 5, directing the court's attention to line 1. Are you being paid by anyone for your time here today?
Nope.
Have you been retained by anyone to serve as an expert in this case?
Nope.
All right, Mr. Hayden, how are you involved in this case?
Well, I conducted an inspection at that Chimes department store in Waco back in 2018. So I assume that's why I'm here.
Moving on to page 8, line 20. Is there any OSHA regulation that does specifically discuss loading docks?
Yes, 1910.28B13 clearly states that guardrails are not required on loading docks because they aren't feasible. You can't very well load something onto the dock with a bar in your way.
Have you had a chance to review the deposition of Kelly Danes?
Yes, I have.
Well, what do you have to say about all the OSHA regulations that Kelly Danes testified were violated by the defendant because of the condition of the landing area in the back of the store?
I'm sure Miss Danes is a very nice person, but they're just reading those regulations too broadly. None of them deal with loading docks, which is what Chimes was using this area as. This wasn't just a stairwell or just a landing area at the top of a stairwell. This was a loading dock. And the provisions cited by Miss Danes don't deal with loading docks.
Was this area behind the store exclusively used as loading dock?
No. It is my understanding that employees also went out there to throw trash in the dumpster and to take breaks. And it is certainly possible that employees went out there and did other things as well. But I don't think that matters.
Why not?
Well, just because an employee goes out and sits on the edge of a loading dock and eats a sandwich doesn't make that loading dock a diner. The key thing here is that Chimes use this area as a loading dock. That's what matters.
No further lines from this deposition, Your Honor.
Any cross?
Yes, Your Honor.
Let's see.
Directing the court's attention to page 11, page 119 of the record, line 4. Do you have any opinion about who was in control of that area behind the Chimes, whether it was Chimes or the landlord?
Nope, that's way outside my bailiwick. I mean, it certainly seemed to me like it was Chimes' property, or at least they were in control of it based on everything they told me.
Moving on to page 11, line 16. Did you ever inspect that area behind the store at night?
No, only during the daytime.
Did you notice a light out there when you were doing your inspection?
I did. You'll see it noted in my report.
Did you ask the manager about that light?
I did, like you can see in my report.
And what did the manager say?
The manager told me they always turn the light on when somebody goes out back at night. So that seemed good enough for me.
Did you have them turn it on while you were there?
Nah, it didn't seem necessary.
Finally, directing the court's attention to page 10, line 5. Do you disagree with the assessment of your boss in this email?
No, I don't. I'm fairly conservative when it comes to issuing citations. Look, I obviously believe that workplaces need to be safe for employees, but that doesn't mean the government should be draconian in enforcing those regulations, especially in times like these when it's hard enough to find a job or a place to work. So maybe I'm a little bit more lenient than other inspectors. That's certainly possible. But I do my job and I do it well. And we talked about this issue and it was all good. It's not like I've been fired or anything.
Thank you, Your Honor. We have no further excerpts to read.
Any redirect?
No, Your Honor. At this time, the defense rests.
All right, and you all want to take a brief recess to ready for closing argument?
That would be great, Your Honor.
Yes, Your Honor.
We'll take about 3 minutes. I'll give you a time check when we come back. All right, we've had our 3 minutes. See Mr. Dowell back with us, or the rest of our jurors back.
I'm here, Judge.
All right, who was that? Is that Mr.
This is Bernhardt.
Bernhardt? All right, I thought that was your voice.
I'm back as well, Your Honor.
All
I'm
right,
back as well, Your Honor, as well.
okay.
Same.
All right, I believe that's everyone. Then on your time check, plaintiff, you have 15 and a half minutes remaining for closing argument. Defendant, you have, you got a lot of time, about 27 and a half minutes.
Your Honor, I do ask that I'm able to reserve 2 minutes of that time for rebuttal this afternoon.
Yes, ma'am. We get that far, I'll give you a time check. Then at this time, we will proceed with closing arguments. Plaintiff, you may open and close.
May it please the court. Counsel, members of the jury, carelessness creates consequences. When people are careless, when they go through life with a disregard for safety, they can hurt others. That's what today's case was all about. Think about what we talked about at the beginning of trial today. We talked about that driver getting behind the wheel of a car after having a few drinks, being careless, putting the safety of others in danger. By getting behind that wheel, we know that that driver is choosing to hurt others instead of just paying those few bucks for a cab. Now, that may seem different from the situation we're here in court today because we know that today's case wasn't about a careless driver, not even a careless person. But it's not that far off. We're here because of a careless company. Today, you heard that the defendant chose to be careless. They chose to get behind the wheel. You learned that Chimes chose their image over their employees. They chose their profits over their people. This company chose to brush problems under the rug, chose to ignore glaring safety issues, chose to be lazy. And one of their most dedicated employees, Miss Jordan Gilmore, she suffered the consequences of their carelessness. Now, you learned that we're here today because Miss Gilmore suffered that injury while working at Chimes, an injury that's changed her life. And as a result, she brought this case against Chimes. You learned that on January 23rd of 2019, Miss Gilmore was injured because of the defendant, because of their negligence. And we had to prove that to you today by a preponderance of the evidence. You might be asking yourselves, what does that even mean? Well, in a few moments, the Honorable Judge Harris will come before you, and he'll give you a set of instructions. And these are your jury instructions. The judge will tell you about the questions that you have to answer today and what the law really even means. Now, Judge Harris will tell you that we had to prove 3 things were true today in order to prove that the defendant was negligent. First, that the condition in question posed an unreasonable risk of harm. Second, that Chimes Department Store Incorporated knew or reasonably should have known of this danger. And third, that Chimes Department Store Incorporated failed to exercise ordinary care to protect Miss Jordan Gilmore from the danger by both failing to adequately warn Jordan Gilmore of this condition and by failing to make that condition reasonably safe. We had to prove these 3 things to you today by a preponderance of the evidence. Now, that all may sound a bit confusing, so I'm going to break it all down for you, piece by piece, step by step, element by element, and show you how we proved every single one of those things to you today by a preponderance of the evidence. Now, members of the jury, a preponderance of the evidence just means more likely than not. It's a mere tipping of the scales. So let's talk about how we met our burden today. I want to take you back to the beginning of trial, when Ms. Gilmore took the stand, and well, she took you back to 2009, here in the great state of Texas in Waco. Ms. Gilmore told you that was the year that she proudly began her job as an employee of Chimes department store. Today, when you met Ms. Gilmore, she told you how she dedicated 10 years of her life to working hard as a cashier, a clerk for the defendant. She told you she was a rule follower. She gave her best day in and day out to do her job and do her job well. Now, you heard that in 2015, the defendant enacted that new policy, that smoke break policy. And you saw this memo. And Ms. Gilmore told you that this new policy said that all smoke breaks had to be taken out back, behind the store near the back door, near the dumpster. And you learned from the defense's witnesses, this policy was put in place to protect the defendant's image. They didn't want customers to see their employees smoking or walk through a cloud of smoke. So they put them out back. Now, this request might seem reasonable to the average employer, but you heard what smoking out back really meant for Chimes employees. You saw the dangerous conditions that the defendant subjected their employees to. You saw that any employees who wanted a smoke break, including Ms. Gilmore, had to stand on that exposed concrete platform behind the store, a platform that was falling apart, a platform without a handrail, without adequate lighting nearby, a platform with literal chunks missing from it. You learned that this was the designated break area the defendants chose for their employees who smoked. But you also heard something very, very important today. The defendant knew that this smoking area was violating building codes, government regulations, and they never inspected it. Ms. Geller said herself on cross-examination, she and no one in her management ever inspected their store for safety concerns. They put that on their employees. They were careless. We've met those first two elements. These conditions posed an unreasonable risk of harm, and the defendant knew it. They knew those conditions were dangerous, and they ignored them. They were careless. And you learned today exactly what that carelessness meant for employees like Ms. Gilmore. You heard about January 23rd of 2019, that cold, windy night here in Waco. We all know by 7 p.m. this time of year, the sun is gone. Darkness has set in. Around that time, Ms. Gilmore and her coworker go outside to take their smoke break. They go out back, just as required. And they open the back door and are met with a gust of wind, cold air. And Ms. Gilmore goes down those stairs, choosing to withstand the cold instead of smoking in the doorway, so that the smell from her cigarette wouldn't sneak inside, like a good employee. But these stairs, this platform that she could navigate so easily during the day, you saw today, it was much tougher to take in the darkness because there's no lighting. And you saw the light that could have been fixed and eventually was. This light that the defendant knew didn't work, knew was a problem, knew because employees had complained to them, but they still left it with no switch installed when Ms. Gilmore was an employee. You heard today there were no street lamps, no exterior lights illuminating that small staircase. Only that sliver of light came through the door. So Ms. Gilmore quickly smokes her cigarette, heads back inside. And as she climbs those stairs onto that platform with so little light, no railing to grab onto, she slips. And you saw where she took that last step. This tiny bit of concrete, these few inches she had to navigate around that door. Look at that exposed pipe, the missing concrete. These were the conditions that the defendant left for their employees. So, with no guardrail to catch her, she falls to the ground. She lands on her right leg, damaging her right knee. Members of the jury, Miss Gilmore told you that after that fall, she had to have her right knee replaced. All because the defendant chose not to prioritize the safety of their employees. You also heard from an expert today, an expert witness named Kelly Danes, a mechanical engineer. You heard portions of Miss Danes' testimony from a previous deposition. I read it to you along with my co-counsel, Miss Letko. Members of the jury, Miss Danes' testimony taught us today that Chimes department store violated numerous federal guidelines. You heard about the guidelines governing handrails, governing lighting, governing staircases. The evidence showed that that area was not safe. It violated those codes. And that the defendant knew it wasn't safe. They knew this platform was dangerous. They knew that the stairs weren't safe. They knew that the lighting was inadequate. They couldn't do anything to fix it themselves. And they didn't even bother to reach out to their landlord about it. Now you learned they couldn't be bothered to make this area safe. This area used not only by smokers, but by other employees. Those who don't smoke instructed to take out the garbage. Employees loading and unloading shipments. The defendant didn't just put Miss Gilmore at risk, he put all their employees at risk. They breached their duty to Miss Gilmore, to all their employees. Their duty to protect them from danger, to keep their workplace safe. They violated that duty. And we've proven that to you today. That was the third and final element. Members of the jury, we've proven that they were negligent. We've met our burden. Now, in a moment, the Honorable Judge Harris is going to tell you about the questions that you have to answer today. And he's going to show you this first question. Did the negligence, if any, of those named below proximately cause the occurrence or injury in question? And here, members of the jury, you can write yes next to Chimes department stores. And you can write no next to Kermit Realty and Jordan Gilmore, because you know Chimes department stores, the defendant, that's who caused Miss Gilmore's injury. And that means that you have to move on to question number 2. Now, Judge Harris will tell you that this second question asks, for those found by you to have caused the damages, if any, to Jordan Gilmore, find the percentage caused by, and then it lists those same 3 parties. Members of the jury, here you can fill in those percentages. And you know that right next to Chimes department store, you can write 100% and 0% next to the other 2. We've shown you today that the defendant was negligent. It was their fault. They chose carelessness. They chose laziness. They chose ignorance.
3 minutes per minute, Coach.
Apologies, Your Honor.
3 minutes.
Thank you, Your Honor. They chose these things over their employees, over safety, and that Jordan Gilmore suffered the consequences of their carelessness. And that's why we're going to ask you to look at the facts. Look at the evidence and apply the law. Find the only verdict supported by the truth. We ask that you hold the defendant liable. Thank you.
Defense,
Yes, Your Honor. May I proceed?
you may.
May it please the court. We're here today because the plaintiff just keeps trying to slip on by. Members of the jury, you heard today about how what caused this plaintiff's injury was when that plaintiff decided they were going to try to slip on by a tiny sliver of space because they just weren't going to grab that door and open it up. So now today, The plaintiff is trying to slip on by taking responsibility for their choices that night. They're trying to slip on by you. And if you fall for this story that they've told you today, a 3-generation local family business and the good of the people who run that business will suffer. I want to talk to you about chimes again, but first I'm going to bring up an exhibit showing where this fall occurred one more time. You saw this earlier, but I really want you to look at this, members of the jury, and see where this dramatic fall took place. A simple exit that was turned into a loading dock behind a store with 5 steps and a couple foot platform. Keep that in mind. Thank you, Mr. Koenig. You can take that down. So let's get back to what we're talking about. Chimes Department Store. They are our clients here today, and they are our community's department store. You heard about how Chimes Department Store has been in Waco for decades. People's grandparents went to Chimes Department Store, their parents, and now we go to Chimes Department Store here in Waco. Reese Geller carries on his family's legacy. He watched his grandfather start this business. He watched his parents take over. And Reese Geller, she decided that she was going to take over. She was going to work from the bottom up, and she was going to earn her place at that department store. She wasn't going to walk in and take over. No. Because that's what Chimes Department Store stands for. We're a local business that believes in family and the community. Today you learned about this loading dock, the loading dock that I just showed you a picture of. You learned about how this loading dock came to be. When Reese Geller's family moved Chimes Department Store to this shop, they wanted a loading dock. Members of the jury, they wanted a loading dock because they were having delivery trucks come every single day to the back of their store. And you know what makes it easier for your employees to safely take boxes off of trucks every single day is when there's not some bars or railing in your way. But when Chimes Department Store decided that they wanted to take out those railings, they couldn't just do it. They couldn't just go in there with some tools and start removing that. And that's because this loading dock is not a part of the area that Chimes Department Store leases. I want to look back at a very important part of the lease that you saw today. Mr. Koenig, could you pull that up? Members of the jury, we established, like you saw, that this loading dock was a common area. And a common area is up to the sole responsibility of the landlord for good and safe operation. It is the landlord's duty to manage and maintain the area in good, safe condition. Thank you, Mr. Koenig. Members of the jury, I want to move on to talking about one of the 2 things that I asked you to listen for whenever the plaintiff took the stand. The first, how familiar the plaintiff was with this loading dock, with this back area of the store. Now, every employee since 2005, when Chimes Department Store moved to that location, has had to go out that door, down those steps, take out the trash, up those steps, and through that door, including the plaintiff in today's case who worked at Chimes Department Store for 10 years. Now, in 2015, when Chimes Department Store instituted a new smoking break policy, employees then had to go out there to smoke, which, as you heard today, the plaintiff said she saw that as a reasonable policy. And hundreds of thousands of times, employees went out there from 2015 to 2019 to take their smoke breaks. including the plaintiff. Members of the jury, the plaintiff estimated that she had gone out those doors, down those stairs, and back up at least 20 times a week for 10 years. And as she estimated for us, that's about 10,000 times. And each of those 10,000 times that that plaintiff went out there, they saw that there was no railing on the loading dock, no railing on the stairs. And you know what? They made it down those steps okay and back up and through those doors. As a plaintiff talked to you guys today, they had a burden of proof today. I want to show you the elements again that they had to prove. So the first one, they had to show that the condition in question posed an unreasonable risk of harm. Members of the jury, I want to talk about how many employees used that loading dock over the 14 years that Chimes Department Store was there, and there were 2 incidences. Members of the jury, I want to talk about how the only OSHA inspector here, a third-party government agent who wasn't being paid to inspect that area, went to that area and found no violation of OSHA regulation. But Kelly Danes, who was hired by the plaintiff, claims that there were tons of violations. But as you heard from the deposition of that OSHA inspector, Kelly Danes was looking at the wrong regulations because Kelly Danes wasn't looking at loading dock regulations. And members of the jury, let me be clear. We are here today because of the loading dock. The plaintiff talked about a bunch of regulations with stairs and all this stuff, but the plaintiff fell off that loading dock. And as you heard today, a loading dock doesn't require to have railing because that would defeat the purpose of a loading dock. The second thing that they had to show you was that Chimes Department Store knew or should have known of the danger. Members of the jury, I'm just going to point out 2 things that I just did. How many times, how many years employees went on that loading dock and took trips into that store, and how many incidences there were. And how when they got it inspected properly, it didn't break any regulations. And lastly, the plaintiff had to prove to you that Chimes Department Store failed to exercise ordinary care to protect the plaintiff by failing to make the conditions reasonably safe. Members of the jury, let me be clear. That loading dock is not the responsibility of Chimes Department Store. The condition of that loading dock is not under the control of Chimes Department Store. That loading dock and the safe conditions of it are under the responsibility of the landlord. Now, the plaintiff, keep in mind, had to prove all 3 of these things to you, and if one of them fails, they fail to show negligence. But that's not the only thing that the plaintiff had to prove to you. They didn't only have to prove negligence. Mr. Koenig, if you could go to the next slide. Now, the plaintiff had to show proximate cause that caused the injury that Miss Gilmore sustained. Now, I want to look back at that picture of that door, because in order to talk about what caused Miss Gilmore to fall, we have to talk about the second thing that I told you to listen to during the plaintiff's testimony, and that was her choices. So let's talk about this. That plaintiff chose during her long smoke break to go out there when she had maybe an hour left. She chose to go down those steps, up those steps. And members of the jury, this is the key moment when you think about proximate cause. Miss Gilmore stopped at the top of those steps and saw that her friend was opening that door halfway open. Miss Gilmore saw the tiny amount of space that was in between the edge of the loading dock and the door. Now, Miss Gilmore knew there were no railings on that loading dock because she had gone on there hundreds of thousands of times, members of the jury. But do you know what she did? She chose to try to slip on by this door. She didn't choose to grab that door and open it further. She didn't ask her friend, hey, could you just back up a little bit and close the door a little bit? No. The plaintiff kept mentioning careless choices. This, members of the jury, is the key to proximate cause in today's case. This careless choice. To try to go around this tiny sliver of space. That is the careless choice that brought us here today. Now, I want to talk about the jury charge that you're going to be given today. So, like the plaintiff showed you earlier, it says, did the negligence of any of those named below proximately cause the occurrence or injury in question? Members of the jury, there's two parts to that: negligence and proximate cause. And as we showed you today, the plaintiff cannot show both of those for us, Chimes, because we don't control that loading dock. And so for that, for Chimes Department Store, you're going to write no. Now, I know that the plaintiff talked a lot about the condition of those steps, the condition that they were in. And if you're upset about that, members of the jury, then you've got to hold responsible who is responsible for maintaining that area. So if that upsets you and you want to hold the party responsible who's supposed to maintain that, you're going to write yes for Kermit Realty Group. But most importantly, members of the jury, you're going to hold responsible whose choices led us here today, whose choices led to this one incident that we're here today for, and that was Jordan Gilmore, whose negligence was a proximate cause in the occurrence of the injuries. You're going to write yes. And this last page, members of the jury, the percentages that we talked about earlier. Listen, we already showed that Chimes Department Store wasn't negligence. You're going to write 0% right there. But when it comes to the next two, I'm going to leave that up to you. I'm not going to tell you what percentage you should assign to a careless employee and an absentee landlord. That's up to you. But because they failed to meet their burden, you have to write 0% for Chimes Department Store. Thank you, Mr. Koenig. Members of the jury, we are here because of careless choices. But the fall that took place on January 23rd, 2019 was from careless choices made by the plaintiff. Because that plaintiff tried to slip on by a door that was blocking their path. Don't let them slip on by taking responsibility for their choices. You can do that today by finding us, Chimes Department Store, not liable.
Plaintiff, you've got a little over 2 minutes to close.
Thank you, Your Honor. Members of the jury, the defense just got up here and said that the plaintiff slipped on by. No, that's not true. Because it was the defendant who forced their employees to slip on by. The defense is pointing fingers at anyone they can today, pointing fingers at everything but the truth. So let's talk about the two other people they want to blame for Miss Gilmore's injury. They want you to blame the landlord, Kermit Realty. They want you to believe that Kermit Realty had control over this space, but you know that's not true. Because we showed you today, Chime Department Stores installed a new light switch. They had control. They had the ability to do that for 10 years. And they didn't. Not until after Miss Gilmore's fall. And even if you believe, for some reason, that that Kermit had control, that Chimes didn't, then think to yourselves, well, then why didn't Chimes tell their landlord about these dangers that they knew about? Why didn't they alert them of those stairs, of that light? If it wasn't under their control, why wouldn't they just shoot the landlord an email and say, hey, can we fix up those stairs? Can we fix that light? They had control. And even if you think they didn't, they still had a duty and they breached it. And they also want to blame this injury on Miss Gilmore herself, a woman who's had to have her entire knee replaced as a result of this accident. Now, they talked a lot about how Miss Gilmore had been on this platform thousands of times. Now, let's just say that Miss Gilmore had been on that platform 100,000 times over the course of 10 years. Members of the jury, all it takes is one time, one incident, and that's why we are here today. One time to shatter the knee of a veteran employee. They let their employees' safety slip on by. Don't let them.
Ladies and gentlemen of the jury, this matter will now be in your hands. All right, counsel, stand down a moment. We'll get our ballots completed and we'll come back and give you some brief critique. All right, so judges, if you would make sure that your ballots are sent in and join us once you've sent them in. Once I get a thumbs up from the powers that be, then we will, of course, call it a day, but you're free to make your comments to the lawyers. First of all, my name is Lee Harris, as you've seen on the monitor. I'm about to finish my 16th year on a state court bench here in Texas. And so this is my real job, although I also work at and I'm on faculty here at Baylor as an adjunct in the practice court program. We've been asked to make some kind of brief comments to you as to both of you. I'll say a couple of things. I felt like you had immense talent, both of you, but in a 55-minute time frame, both of you used somewhere in excess of 24 minutes between your opening statement and your closing arguments. That's probably overdoing it by quite a bit when nearly half of your time is spent there. Another thing, and this is just a personal issue, there was a little bit said about depositions in opening statement, but jurors often don't know what they are. I feel like as a lawyer, you ought to say to the judge when you're going to call somebody by deposition, either before the trial starts or at the time you choose to call them, Judge, would you like to explain to the jury what a deposition is so they'll understand it, or may I do so? And it all depends on how I feel on a particular day. As the judge, I'll either say, give it a try, and if you don't do it well, I'll fix it for you, or I'll go ahead and explain, because jurors don't really know that those people have taken an oath. They don't know that they've been told it has the same force and effect. Ms. Appler, one of the things that just really caught me was when I asked if there was anything else, you said nope. Nope is not a good response in a court at law. There are formalities. I know that you all in this generation, are used to a lot of texting and all, but I would be very careful responding to a judge with nope. Yeah, but like I said, I thought very immense talent. Ms. Kasimsi, I like the fact that you brought out the Waco connection, the hometown, and Ms. Appler, I heard you say, but you said it a couple of 3 times, and I think it may have oversold, but I thought it was good that you did mention the state of Texas. And I'm going to turn it over to some of these other folks. Mr. Dow, you're at the top of my screen. If you want to start, go right ahead. Your law firm is the one who puts this whole matter on, more or less. So.
Thank you, Your Honor. Let me echo what he said. First off, these things are so hard from our side. I can only imagine what it must be like trying to play this to a camera. But from our side, trying to figure out, was this better than that? And we're talking some pretty fine tuning. So congratulations to both of you. One thing that I think I really enjoyed both of you doing was trying to turn the other's words on them. Trial themes are hugely important, but you've got to be really careful that it's not something that can be twisted back at you. Ms. Appler, the carelessness creates consequences. If were I the defense counsel, I would have started an opening statement, or excuse me, an opening statement, and all the way through it, saying she's right. We don't agree on much, but she's right. Carelessness does create consequences. Carelessness, like not opening the door, like going out when it's dark, like she knew that rail wasn't there. And I'd really bust into that. That's almost the kind of thing that you might set up and then hold till your final closing. However, I thought you did a very good job at turning the slide on by against the defendant. And I guess anytime I'm a defendant, I argue for a 0, but I give them another number. If you think we're responsible, then fine. We're 10% responsible. Give them something to land on, so that, because there's always, horse trading going on back there, even though the judge tells them not to. The last thing I would say, both of you did very, very good jobs on your cross-examination, but cross-examine, just like you did in your openings, cross-examination and direct examination needs to build to a crescendo, and you need to leave the jury hanging on the edge of their seats. Ms. Appler, you got to the question of, and what did she tell you when you told her about the accident? And here's this great admission. And then you asked a couple of questions after that, and I don't even know what they were. That should have been the last thing that was ringing in the jury's ears, so that the defendant needs to jump into that, take them off their game. Anyway, I've said too much already. Great job to both of you. Congratulations.
Doesn't matter to me, whoever wants to go next.
Yeah, I'll go quick, Your Honor. I would echo everybody's comments. I'd be proud to try a case with both of you. So you guys are on a great route here. What I would be careful of going forward in competition, and when you start doing this for a living, is don't overpromise an opening. Don't oversell. Frankly, your adversary is going to order a transcript of your opening and jam it down your throat in closing if you say something you can't prove. I'd be careful in opening of being too argumentative by using words like laziness. I think you can use different words than that, particularly if you're a plaintiff and there's a local defendant in the case. Your jurors shot there. They might go to church together. There's a way to describe their negligence differently than laziness. I think in Texas, we probably argue a little more in our openings, kind of a rubbin's not racing philosophy than some jurisdictions do. So argument's fine, but just be careful of your word choice. It can be used against you later. I think on the plaintiffs, I would have taken some redirect just to have some lingering moment of your own client there, so the jury hears something, even if it's something as basic of, your expectation is, your employer's going to provide you a safe workplace, yes, and end it. I mean, just add something to it so someone doesn't get the last word. But I thought both of you did a really nice job with your tech skills. I thought that the arrow drawn was frankly the emblem of the whole case. That little red arrow, that little window, that's, frankly, if this gets submitted, that's going to win or lose the case when one evaluates whether it's a substantial risk of harm when the premises question gets submitted. But yeah, I thought both of you did a great job. These are difficult environments. 24 hours is a difficult time frame to gather all the evidence, formulate a story, sew a story together. Capturing a trial theme, I know signpost is the buzzword. I typically call it a bumper sticker of the case. I'd be careful on drawing a parallel that maybe is not too virtuous. I think drunk driving case is a pretty far stretch to compare to this case, frankly. And that can backfire on you a little bit. But I know that in 24 hours, you're scrambling to find something. So, I applaud the fact that there was, something we could all grasp on. But yeah, you guys did great. Our bar's in good hands with folks like you going on trying cases for the next 30 years.
I guess I'll go next. So they told us in our judges meeting to keep it to one constructive comment that you can use for the next round. So I'm going to try to do that just because we could be here all day talking about all the good stuff you guys did. But I do want to echo a global, thumbs up to both you on your presentation style and your demeanor. You both carry yourself very well in the courtroom. And so good job. Okay, Ms. Appler, my constructive criticism, if you want to call it that, feedback, is I think that you've got to, or, I know you guys switch sides, but I think whenever you're playing the plaintiff's lawyer in this case, you've really got to take out the landlord pretty quickly in the case, right? Because their whole case is pointing the finger at the landlord. And you spent a great deal of time in your opening and closing talking about why the department store was liable, but you never knocked out the landlord. You never gave us a really good reason why the landlord isn't liable.
Go, keep going. I'm going to go make sure we're okay on our balance.
Okay, so that's just if you're play the plaintiff in the next round, I would say you've got to take on that burden as well. Otherwise, the defense lawyer is going to come in and do exactly what they did, which is there's this gaping hole there to be filled, and because the plaintiff hasn't really addressed it. So that's just my thought on that. Okay, Ms. Kasemsi, my feedback for you kind of is consistent with what the other gentlemen have stated, and that is that I think in this process and in real life, themes are very important. And I guess what I would say to you is I don't know, what like a really good or perfect theme would be for the defendant in this case, although I happen to represent non-subscriber employer in Texas. But slip on by is not a good one. I would ditch that theme. Just to me, I thought it was too cute. And I know what you were trying to do with the graphic where you showed how she slipped down that little, sliver of the stairs. I would just pick a different theme because I almost cringed when you kept saying it in closing. Themes are important. And so pick something that's maybe a little bit less cutesy. That's just my suggestion. But great work to both of you. Really good job.
Yeah, and I guess I'll round us out here. I really want to build off what Jason said, in that I think you both did an excellent job, especially just given the fact that you have 24 hours to prepare for this. And so I'm only my second year of practice, so I remember being in your shoes, and I always wanted to know, okay, what do I need to do in the next round to get some more points? And so just to be very specific, maybe even nitpicky, I think, Zoe, for you, I think it's a question of the strategic pause. I think you hit everything you need to hit, but I think maybe David mentioned it earlier. There are some times you made great points on cross and even in your closing, and you made that point and you got that answer, and it probably would have been more impactful if you just left it where it was and just let silence speak for itself. When it comes to your opening, in terms of that strategic pause, you have that first paragraph, I would say, talking about the case, talking about your theme. And I felt like you finished that and it was very strong. And then almost immediately you said, "Good morning, my name is," and then we kind of lost some of that impact. So I would just say leave it, or just move right into introducing yourself. Your closing, I would say make that more concise. You did an excellent job moving through the exhibits and how they dealt with your elements of your claims. I think you could probably make it more concise. You don't want the jury to lose track. You don't want to lose how potent it is by maybe going on a minute or two over it. So that's what I would say. Miss I'm sorry, Miss, is it Jack? Is it? Okay, sorry. I don't want to butcher your name here.
Everyone does. It's fine.
I would say there was a cross-examination. I think it was the plaintiff's expert. I know it's really hard to deal with the deposition testimony aspect of this. It's just a tough thing to have to deal with. You went in on cross, and I was kind of confused about what you're trying to get there. I think you asked a question, how many times or how many inspections have you done? It said 60 and then rested. I know it's tough to deal with, but I just felt kind of confused. I wasn't sure what I was supposed to get out of that. So maybe rethink that cross. Also, when you wind up your cadence, when it feels like you're building towards, kind of a critical question or a critical point in your closing, make sure that there's a point that's going to really hit coming after that. I felt like there was a time in your closing where you said, "Listen," and I paid attention because you told me to, and then the next point, it seemed like you kind of trailed into something. I would just say make sure that is your signpost and you hit a big point going into that. And also just explaining why. There were a couple times I heard you make distinctions between the light inside, the light outside, the dock versus the stairs. Those are all important distinctions, but I felt like there's just that last segment of why is this important that maybe you should focus on fleshing out more, maybe for future judges. But overall, I think you guys were both great, especially given the circumstances. You're doing this on Zoom with 24 hours notice. It's not ideal, but you guys are awesome.
Mrs. Bolton.
Hi, everyone. My bandwidth is running a little low, so I'll try to keep this short. Y'all were excellent. I'd be very proud to have either one of you practicing in my court. You all were fabulous. Just some stylistic points, because I think the guys really hit all the substantive matters really on the head. I completely agree, Ms. Zoe, the pauses are important, and pauses can do you wonders. And there were so many important points that you were making that I missed just because it seemed like a run-on sentence. So maybe just work on that for the next round. Ms. Kasimsi, I thought you were excellent. And my favorite thing about you two is there are several ways to try this case, and you all responded really well to the points that each other was bringing up. That's hard to teach, that's innate. And so just keep doing what you're doing there. But Ms. Kasimsi, the one thing that I kept focusing on in your closing was you have signposts in your words. You have like comfort words you go back to. And I do that all the time too when I used to try cases. And yours is, I want to talk about. And it can be very distracting if it happens too often. So just watch that in the next round. But other than that, you all were both excellent and you're going to be fabulous attorneys.
I got word that our ballots were, I guess we didn't screw them up too bad. I got a thumbs up. So we are done for the evening. Thank all of you, and good luck to you two if you make it to the round of the Final Four tomorrow. And it sure wouldn't shock me if one or both of you are there.
Thank you so much for taking the time, everybody, to take time out of your Saturday night to do this with us. We really, really appreciate it.
Yeah, thank you guys.
Happy to do it. Y'all take care. Good luck.
Good luck.
All right.